Just this? Okay.
I know, who would have thought?
I know that.
Good afternoon. The Memphis and Shelby County Board of Adjustment is hereby called to order for a regularly scheduled meeting of April 27th, 2022. My name is Tim Rainey. I'm chairman of the board. Mr. Brett Ragsdale serves as secretary of the board. Mr. Ragsdale, may I get a roll call, please?
Yes, sir. Ms. Baker?
Here.
Mr. Claybrook?
Here.
Mr. Jackson?
Here.
Mr. Malazri?
Here.
Vice Chair Savage Towns?
Present.
Chair Rainey?
Here.
We have a quorum.
All right, thank you. The Memphis and Shelby County Board of Adjustment is the oldest appointed governmental body in Memphis and Shelby County. We were established in 1925. The board hears appeals from the administration of the zoning ordinance, requests for variances from the zoning ordinance, and other requests as articulated by local zoning laws adopted pursuant to the enabling legislation. The 8 members of the board are appointed, 4 by the mayor of Memphis and 4 by the mayor of Shelby County, with confirmation by the Memphis City Council or the Shelby County Board of Commissioners. We serve without remuneration. At this time, I'd like to swear in the staff. You may all remain seated. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. May I get a motion to approve? We have several months to approve on minutes, so let's get a motion to approve the March minutes first.
Second.
Is there any discussion of the March minutes? Hearing none, I assume you're ready to vote. All those in favor signify by saying aye.
Aye.
Any opposed? None. The motion carries. Let's then can we get a motion to approve the February minutes?
Second.
All right, be moved in second. Is there any discussion? Hearing none, I assume you're ready to vote. All those in favor signify by saying aye.
Aye.
Motion carries. Also, let the record show that Ms. Sherlock has joined us prior to those votes. And now we have our January meetings, which I'm going to ask for some help on that one to remember exactly what we're voting on. And would Mr. Robert like to help us with that?
Yes, Mr. Chairman, Robert Rowland, County Attorney's Office. This is the motion to rehear the minutes on the item number 7 in January, which was the Barrettville store matter. And the director and the administrator and I thought it would be helpful to go over the rule on motions to rehear, with your permission.
Please do.
Yes, first of all, obviously in this case we're rehearing the minutes only, not the full application, and no new conditions that were not addressed at the meeting should be added. Second, on the rule on rehearing in the board rules, a motion to rehear is done in writing and filed more than 7 days before the next meeting, with notice given to the opponents. Now, Mr. Matthews, who is the movement here, did not file a motion per se. He had an exchange of emails with the planner, Seth Thomas, and the staff treated that as a motion to rehear. And that's important for 3 reasons. The board may not consider that as a motion to rehear. Second, the opposition may object to that as being treated as a motion to rehear, in which case they would need to be heard on that objection. And third, the subject of the email exchange was limited to the lighting condition. There was subsequently another email with several other subjects, but the staff did not treat those as being timely submitted for a motion to rehear. The third point I'd like to make is that recall that the board limited the variance to one matter, which was the expansion of the restaurant. Everything else, as you may know, is the subject of a planned development, which the Land Use Control Board has approved and which is pending before the County Commission. So subjects beyond the variance, beyond the expansion of the restaurant, are properly the subject of the planned development, which is pending at County Commission.
Okay. Are there any questions?
Yes, Mr. Chairman. Attorney Rowland, I have a question for you. You said now our ruling with regards to Barrettville was only for the expansion of the restaurant. Did I quote you right?
That's my understanding, Mr. Ragsdale.
So, I'm sorry.
That is correct, and of course, the site around it, I think the one thing that was removed that was originally part of that discussion was the outdoor entertainment, and that was what was not part of that variance. There was discussion and a condition to not allow outdoor entertainment, which was included in the variance request, or the board's decision.
So I want to make sure I understand what we're saying. If we're saying that the board's ruling, this board's ruling was only on the expansion of the restaurant, but that does include all the conditions that we put on the development as far as we did, is that correct?
Yes, that's correct.
Then my question becomes to, I guess, either staff or you, Attorney Rowland, if the meeting minutes, which in my opinion do not fully reflect what we discussed, how do we get those meeting minutes to reflect that based on the fact that there were numerous conditions on that I think, and I hope some of my other board members agree, should be included in that so that when other boards, councils, commissions read it, they have a full and thorough understanding of where the Board of Adjustments was with regards to that case. Can you help me with that?
Well, yes, of course, that's the purpose of the hearing today, is to amend any conditions incorrectly stated, or to add conditions in the minutes that were approved but did not make it to the minutes. And having said that, anything that goes beyond the variance itself, the board would not have jurisdiction over. That jurisdiction would lie now with the county commission in the planned development.
Yeah, I'm crystal clear that, you know, they can appeal to a higher authority, which would be, I guess, county commission. But in order for the county commission to fully understand where we are as a Board of Adjustments, they would need to have accurate and correct meeting minutes, which should reflect some of the things that it does not reflect at this time, correct?
That's certainly one way to look at it, yes. One correction.
I'd like to know your legal opinion of how we look at it.
Should the county commission have all the information necessary? Yes, I agree with that. Now, one correction though, the planned development at the county commission is not an appeal from here. That's a separate vehicle altogether. Appeal from the Board of Adjustment is direct to court.
Yeah, I'm sorry, I didn't mean to use the word appeal. But I think they should have the full documentation of how our thought process was relative to that case. So in making their decision on any future aspects related to that project, they will understand where we were. Which then means that not only are we talking about lighting, we're talking about other conditions that were not in the meeting minutes. Would you read it that far?
No, as I said, the staff considered the only timely submission was on the lighting.
That may be the timely submission, but the accuracy of the meeting minutes as they stand now are not correct. And to get them corrected, how do we do that?
It's a majority vote.
Thank you, sir.
Yes, ma'am.
Mr. Rowling, I have a question. The first thing is, I feel like I'm at a disadvantage a little bit because it's been so long since we heard this case. And so there's just a whole lot of it that I'm fuzzy, you know, my recollection of what all we talked about. But I'll say I do remember one item, which was a large parking lot across the street from the property. There was a fair amount of discussion on that and the feeling that, I can't remember, it was either not needed or certainly not needed at the size. Am I talking about something I shouldn't be talking about?
Well, to answer your last question, the staff says yes, you are. But I would defer to Mr. Ragsdale on exactly what the condition was on parking. I know it had to do with the angle of parking and the availability of parking.
Yes, Ms. Baker, I think to answer that question, we did have a condition, number 3, no parking shall occur east of Barrettville Road. So that was the discussion. So if that was your question, that
Okay, so then I guess I'm with Mr. Jackson that I'm wondering if none of that is in the record. I don't guess. Is it?
No, you said that there's no parking east of Barrettville Road, so we don't allow anything east of Barrettville Road. That was a condition. So
And that's a condition that would not be overturned by a plan development.
no, I don't believe that. They can apply for that through a plan development as well. But the condition at the January meeting that was decided on had a condition to not allow the parking east of Barrettville Road as part of that variance request.
But we could say whatever. If they get a plan development overrules any variance we have, right? Because they've set up their own plan that was approved legislatively. Correct? Okay.
And Mr. Chairman, for just clarification, the reason why I want the meeting minutes to reflect all of the accurate points is whoever looks at the PUD should have the benefit and the thought of this body relative to making their decision. And as it stands now, the meeting minutes do not fully reflect the board's intent relative to that project. And therein lies where I have the issue. And the fact that, Attorney Rowland, correct me if I'm wrong, you said we cannot, based on the staff's saying that that's not part of the meeting minutes. I have a real problem with that.
I have a question, though.
No, well, no, that's not what I said.
I'm sorry.
I said that that was the staff's conclusion. The chairman can make a different conclusion. The board can vote to overrule the chairman.
Okay, thank you, sir.
I do have a question on, this is probably more procedural than anything. In the minute notes, and I think we talked about this, Mr. Jackson, are the recorded sessions included in those reviews, or is it just notes from the actual decisions? You know, we have discussions and they are recorded. Are the other bodies able to view and see those as well as the minute notes in conjunction, or?
Mr. Chairman, yes, the recording is always, or actually a transcript of the recording is made a record of the case if it goes further than the board. The recording itself is always available on YouTube and on the city council website. We're being recorded right now.
Okay. So only the transcript of the full body discussions are sent if it's appealed, or what's the order?
Yes, the transcript is sent, is filed in court if necessary, and with a citation to the YouTube and city council websites.
But in this case, just, you know, that information's available, but like county commission could never even ask for it. Because, I mean, they're just doing their own thing compared to what we've done. They may want to ask for it.
Yes, and I'll also remind you, as we said earlier, that their case, the plan development, went through the Land Use Control Board, which is also meets here and is recorded.
Sure.
So, Mr. Chairman, if I may, what I'm saying is that, first of all, I think it's a flaw, in my opinion, in our meeting minutes that we're doing now. I think that the voice recordings should have a link on our official meeting minutes that can be clicked on. Therefore, any and everything that's not exact in the meeting minutes is clarified with that transcript, and whoever reads those meeting minutes, whether it's in a court of law or just outsiders, have access to it to fully understand the board's discussion and the board's conclusions. And I would like for us as a board to consider that as moving forward in the future, because I think that's very important.
Legal minds thinking through that. As I'm sure Mr. Rawlings is. The problem I think I would have with that is that you got to have something written down. That, I mean, we end up discussing so much that if there's a case where we don't clearly state the final deal. Now we just have this record that didn't help at all anyway. I think that the ruling thing always has to be what's written, and it's up to us to maybe do a better job of making sure what's in those minutes we approve was what we approved. I mean, that's where the mistake, I mean, not that maybe it wasn't transcribed into it correctly somewhere, but then we also missed it then.
Sure.
I don't know that the recording would do anything if there was really a question, because it's going to be like, well, he was saying this and he restated it differently. What really is the final thing? I think there's got to be something that's final so we can all agree this is what we talked about. That makes sense?
It does.
Yeah.
I'm sure Attorney Rowland would be much happier with that.
Well, yes, legally, the courts consider a board speaks through its minutes.
Okay.
I mean, so much is discussion that, yeah, I'm not saying it shouldn't be there
Sure.
for viewing, but as far as that being
The official document.
any official document, I think it's an exhibit of what happened, but the minutes are the minutes.
Okay.
I think so I think our question right now, Mr. Rowling has spoken to us of what he thinks. We have the staff's opinion of what was appealed, and that being what we should discuss. And we're being told we can take that as, hey, we can talk about the lighting, or do we want to overrule that and talk about whatever may be the case?
Mr. Chairman, I'd like to make
Yeah.
a motion that we hear everything that should be included in the meeting minutes and not just the lighting.
Is there a second?
I'm going to second that because I'm like Ms. Baker. It's been a minute, so I've got to refresh my memory.
Okay. Moved to second. Is there discussion? How is that process going to take place? Is that going to take place today? Do we need to get some sort of actual written report to be able to more fully, hey, this is what staff thought, this is what one side says the minute said this, staff says the minute says this?
I think,
Yes.
Mr. Chairman, to be fair to all parties, yeah, we should really hear something. We should have something written in front of us that talks about all the things that need to be included, and opposition and the applicant should all be here to hear what we have to say.
Okay. So,
And I hate to belabor it, but to be fair to all parties, I think that's the only clear way to do it. And I think because it's been so long, the board does not have a good recollection of
Right.
all of the items.
I would then move to hold this until the next meeting with the goal of getting written statements from both parties.
Staff had a question.
Did you have a question, Mr. Ragsdale? Okay.
No,
Oh,
staff.
Seth, or Mr. Thomas will be official.
So yeah, Seth Thomas, Office of Planning and Development. So this case has been forwarded to County Commission with a hearing on May 9th. If in fact County Commission approves this plan development, the outline plan conditions that it's approved under and the resolution that will come out of the County Commission minutes will supersede this variance. And so in some respects, rehearing this in a month, if in fact it is approved by County Commission, will be moot from a legal standpoint, as the County Commission resolution will supersede any and all conditions granted by the variance that will be reheard.
Okay. That
Just
may possibly
giving
less work for us
context.
next month. But thank you for that clarification. If we are not moot by next month, I think we'd like to have all sides give what they think the conditions are. And when maybe when we get the staff reports or whatever that sits into us, if we could get a link to the audio so we each can listen to the audio and just kind of come back with that.
Mr. Chairman, I have a problem with that.
Okay,
because
go
I
for
think,
Yeah.
Mr. Thomas makes an excellent point. My point of bringing this up is for the county commission to have correct meeting minutes in order from this board to be able to make a decision. And if it's a moot point that they're doing it before we get a chance to give it to them, then I withdraw my motion. And I think we should do it today.
Well, it was my motion, or did I you gave the motion to
I
hold
gave the
after I asked for it?
Yes.
Okay. Yeah.
So,
Okay, then we have a withdrawn motion. Does someone else, while we're here, still want to make a motion to hold and push this to see what county commission says? Or
Mr. Chairman, I might want to do that. Are all the parties here? The applicant, the opposition, and so on? It just seems like they would need to be here if we were going to rehear
Right,
it.
and real quick, without going on the record, are you applicant or opposition?
Opposition.
And so
And I'm the one who submitted a transcript.
you're the appellant, correct?
Yes.
Okay, just making sure. That's what I thought. Is the applicant here?
I don't believe the applicant is here. I guess for slightly more context, the condition that is being brought before us originally, before any motion is made, so the one that's being brought by staff specifically has to deal with lighting on the parking that is to the western side of Barrett Road. It was a lighting condition that was left off. That was, once we were made aware of that mistake and we, did I reached out to both the applicant and we brought this back before to be reheard. The applicant is accepting of that condition. That condition's been added to the site plan for this Board of Adjustment case and has also been added as a condition for the plan development. And I believe because of their approval of that added condition, they are not here today as they just assumed, I guess, and maybe falsely so, that this would be, that just the lighting condition, which they have already agreed on, would be approved, and that would be the end of it. So I don't believe they expected a full rehearing, which is why they're not here.
Understood. Okay. Any other thoughts? Does that help or hurt your decision on that, Ms. Baker?
Well, why don't we do this? Go ahead and hold it, on the chance that the county commission might decide not to act on it when it's before them. And if that happens, then the case could be withdrawn or held before we get to it.
Mr. Jackson's point is, to restate it just so I understand it, is that he wants our voice heard of what we thought. And I see that. I don't know that they care. And, the whole idea of going through LUCB and that process is a larger process that's a legislative process as opposed to more of a judicial thing. So it's supposed to be broader. It's heard multiple times. It's stuff like that. So I think that, they have the power to not overturn us, but they just can decide what they want no matter what we decide.
Well, it's a different process.
Right, yeah, exactly. So I understand that. I don't know how to give you more of a voice to at least say, this is what we've tried to do, but I don't know how to really have the case right now on it without both sides here.
Well,
What I
what
feel like I
about?
could really adjudicate well without having that information in front of me. That's my issue, but I do understand where you're coming from.
What about making sure then that county commission sees a full transcript of the content of the meeting? Not maybe every word that was said, but listing of the concerns by the board members and so on.
Mr. Rowling, there is a written transcript of the meeting, correct?
No, there's not.
Oh, it's just,
It can be made, and I don't know, Mr. Matthews, I believe, has one maybe.
let me swear you in real quick, just to go ahead and give your name and address for the record.
Paul Matthews. I live at 8993 Barrett Road in Barrettville, and I was one of the opponents of the application.
Correct. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, tell us what you know about the transcript.
I had a court reporter here that day who transcribed the hearing. I submitted it when I submitted my proposed revised notice of disposition. What I did was, I was present and I also read the transcript repeatedly, and I made a annotated, if you will, version of what the notice of disposition should say, citing to the transcript page where my understanding of what the board did was something different than what was in the notice of disposition. My interest here, and I would hope it be the interest of the board, is to have accuracy.
Sure.
And the notice of disposition is not, it's incomplete and it's inaccurate. And I will say, with respect to the staff's objecting that I didn't bring forth all the discrepancies initially, the whole process before the Board of Adjustment allows for amendments from beginning to end. When an applicant makes an application, it can be bare bones, and they're constantly amending it. And so I think it would be unfair to restrict the correction of the notice of disposition to just the question of lighting. And I realize it's been a long time since the matter was heard, but again, you have a transcript and you have my suggested corrections. So, and I submit it's really not all that complicated. And I wonder too, I don't know if there's some way to, I don't know how the hearing before the the county commission was set, but I wonder if it couldn't be postponed in light of this situation.
I think that would be possible, but not by this board. It would be presenting to them, hey, we want this to be postponed. You know, we don't have power to postpone anything. Well, I'm sure you know.
I could be wrong, but I thought that the date before the county commission was set after certifying or something by the county attorney, and the county attorney's here. And in light of these circumstances, could the county attorney say it's not ready to be heard by the county commission?
Mr. Rowling, do you have any thoughts on that?
The resolution or the project, the PD, goes automatically from Land Use Control Board to the County Commission, and the time is governed by the UDC. So it's pending before the County Commission. It seems to me that the simpler thing to do here is for Mr. Matthews to make his concerns known to the County Commission, which is the next step in this process.
I understand, but that's awfully hard to gear up for a hearing and everybody else is geared up and then say, let's wait. If it could be continued now before everybody gears up, that's so much more efficient. But in any event, I mean, I just think this board has a very high interest and responsibility to have its notice of disposition be accurate. And it's not, in my understanding. The board can disagree with me. I don't think they will, but it's just not accurate. And that needs to be corrected and corrected in time for the county commission to take it into account.
My thoughts, anybody can talk. I don't think that there's anybody on the board that wants it not to be accurate, but we also want it to be adversarially done. And I don't feel I can do that in this meeting without the applicant here. It may end up being moot, it may not. We'd love to see you next month, or I would love to see next month if that got postponed. I just don't know how I can control either of those things at this point, but I'd love to hear what other board members
Well,
say
so,
to that.
Mr. Chairman, I would go back to maybe the only thing we can do is go ahead and set another hearing for us next month, and meanwhile, you and others can try to get the county commission to not act on it, and then we can, if they don't act on it, we can correct the errors, hear it again and correct the errors.
Let me ask staff a question. I know that Mr. Matthews presented his transcript, which I would assume would be correct. I don't know. I've not read it. Did you all listen to it and read it with the actual recording, Mr. Thomas?
So there's sort of two things here. So we agree with Mr. Matthews that the condition on lighting was left out of the minutes and subsequently left out of the notice of disposition. That's the reason why this is being reheard today. However, I think the other sort of red line edited notice of disposition that Mr. Matthews sent the day before the what I believe would have been the February Board of Adjustment meeting is much more, I guess, opinion-based necessarily than it is what was actually discussed, whereas we did leave off that lighting condition. A motion was made by Mr. Jackson to add condition number 7 of Mr. Matthews' proposed conditions to the conditions of the Board of Adjustment case, which was left off. However, I think some of the other edited parts of it are more of an interpretation that Mr. Matthews made and not one that staff made, which is realistically what you guys are voting on. You're voting on our interpretation as opposed to the opposition's interpretation. So there are two kind of separate things going on here. While staff, we agree that the lighting condition was left off. Some of the other things that I think Mr. Matthews is talking about, I would say we don't necessarily agree with. And also that they were not done in the time frame needed to appeal this Board of Adjustment decision. To be honest, the lighting condition, which was brought up by Mr. Matthews, was done after the time to appeal those decisions, and we, out of courtesy, because of the mistake we made, are bringing it back here to add that lighting condition. However, those other things are in our opinion, of course, this is up to the board, not relevant to this case, and this, we believe that staff strictly should be the lighting condition that was left off.
Okay.
Just for clarity, if I may, I hear the staff saying that they disagree with my proposed modified notice of disposition. I did not hear him say he disagreed with the transcript. So the board has the transcript, and the board can decide, looking at the transcript, whether the notice of disposition is correct or needs to be modified.
That, I believe that is accurate. I do not believe I can do that today. That is my issue. Did you have a question?
Sure.
I have some other
Mr.
ideas.
Thomas, I'd like to say to you clearly that staff did not get those meeting minutes correct, because I am very explicit in what I remember I said. And one of the conditions that you have in the meeting minutes is that the parking lot to the west would be an employee parking lot. No, sir, that's only half of what I said. What I said was the parking lot to the west would be employee parking, and it would all be removed except a 90-degree strip of parking off the drive-aisle. That's where I came from on it. So if you're telling me that the staff has the meeting minutes correct other than lighting, no, sir, for the record, you do not.
That's not what I'm saying. What I'm saying is that the lighting condition specifically, which was left off because you made a motion specifically to add it to our conditions.
Yes, sir.
That's a motion that you made, and that's a motion that we did not, add to the minutes. However, as far as a motion being made to edit that parking strip, that's something that I'd have to go back and look into. However, again, those particular things as an addendum or as a appeal to the Board of Adjustment decisions those weren't filed, right? So all of this is, I guess, what's the word I'm looking for? I guess not necessarily unexpected, but not, I don't
Please
think
don't
we're
say it's not
necessarily
relevant.
ready to rumble, so to speak. I'd have to go back, and I was under the impression that this would be about adding the lighting condition that we admittedly left off. And again, I guess, agreeing with Mr. Rainey, I do feel that a lot of this is sort of improper, considering Cindy and Mr. Wilson aren't here to say their piece.
Mr. Chairman, if I may add, just to clarify, and Mr. Jackson, what I heard Mr. Thomas say is that not that what was accurate, but that what we got from Mr. Matthews, some of the red lines were more of an interpretation of what he thought. That's what his statement was. So I just wanted to clarify that.
Thank you, sir.
May I ask Mr. Thomas a question?
Sure.
Mr. Chairman, when you create this notice of disposition, do you turn to the applicant and say, okay, incorporate all the changes that were approved here in the site plan, and then attach that site plan to the notice of disposition?
That's correct.
You do that.
Yes,
And so it reflected all of the changes in the parking and so on
That's correct. And after the lighting condition was left off, I reached out to the applicant and said, hey, this is a mistake that we made. Could you add this to the site plan? They sent me an updated site plan, which was subsequently uploaded to Acela and filed to the building permit for that restaurant expansion.
I'm just trying to think through something on this. I think the board probably all agrees that the final minutes on this case don't reflect the full discussion that we had. I don't know how to absolutely change that today in a fair way, but I wonder, and Mr. Rowling or Mr. Rags will help me, is there some sort of decision we can make that we can, resolve to send something to the county commission? Send them a letter from the board that we heard this case. The board does not fully agree that all the conditions in our case were properly in the minutes, and we invite them to review the transcript, review the recording, if they would like our opinion on it. I mean, they have a separate case, but at least we could reach out to them to say what the decision that happened there that's in the minutes we don't know that it fully reflects the board's decision, and that we were going to rehear that on a date, the next meeting, so they know that is something pending on our board.
Yes, the board could do that. There are two problems with that. First is making it clear what exactly is missing, because we haven't agreed on that yet.
That's understood, yeah.
Yeah. And then second is, well, that's the main problem.
Well, Attorney Rowland, I have a question. Can you review the transcript and clearly say what's missing in the letter for us?
Well, I could, but of course that's always subject to correction by this board. I mean, Mr. Thomas, for example, he wrote minutes, and Mr. Matthews did not agree with those minutes, and neither do you. I'm glad to try, but that's the problem with doing it that way.
I was just trying to process with no minutes in front of me.
Mr. Chair,
yes,
at the
sir.
very least, I submit that the county commission needs some sort of formal notice that the Board of Adjustment considers the minutes and the conditions to be, or the correct recording of the conditions to be a matter to be resolved, and to be resolved on a such and such a date. I'm not opposed to referring it to Mr. Rawling, but I do think there's a good bit of merit in having something in writing, formal, from this board to the county commission, advising them of the situation, even though it's not fully resolved.
Right. Mr. Thomas?
So I think the thing that we're also sort of missing here is that the outline plan conditions that were filed by the applicant for the plan development, I believe it's PD 003CO, were heard by the Land Use Control Board as well. And so that it's sort of my understanding, and of course Mr. Rowling can correct me, but the county commission is beholden to the outline plan conditions reviewed by Land Use Control Board, not by the site plan and restaurant expansion that was done by the Board of Adjustment. Now, of course, I'm sure I'm not a lawyer. I'm sure Robert maybe has something else to say, but that's my understanding.
That's accurate.
Well,
I mean,
Ms.
that's
Thompson,
absolutely accurate. Yeah, go ahead.
Ms. Thomas, if that, you're right. And my problem is that not only does the county commission not going to have the full story, obviously neither did the Land Use Control Board have the full story based on what you just told me. And you and I both had a conversation, I believe, on the phone prior to the Land Use Control Board meeting. And I asked you to make sure that the Land Use Control Board understood this board's position, did we not?
That was done. Those the transcript, all the opposition documents, those were added in the staff report.
Now, I'm not just talking about, I'm saying for you to make sure that the meeting minutes and all the information relative to our conditions were to be considered by the Land Use Control Board. So I want to make sure I understand what you're saying. You're saying that the Land Use Control Board had all the items relative to the conditions correctly in order to make their decision. And I'd like a yes or a no on that, please.
I would say yes.
But if that's the case, we wouldn't be having this discussion, would we?
I would say no.
Well, I would say that again, this discussion is specifically about the lighting condition specifically. That was left off. That is what we're discussing. That's the official thing that was forwarded to this Board of Adjustment.
Mr. Chairman.
All of this other stuff is up to you guys as a board members, which of course I'm not able to do as a staff member. I can only do what we officially mistakenly left off, and that's what I let the Board of the Land Use Control Board know. Right? This other stuff that's been pulled, I wasn't aware. You know what? We were not aware of this, if I'm making any sense.
Mr. Chairman, in order not to waste any more time, and I'm not saying we're wasting time by trying to get something correct, we're not. However, we do need to move on. I recommend that we just send a letter to the county commission that says that the meeting minutes were not accurate. We're in the process of going back through to correct that, and we would like to forward them a set of that, but it will not be ready for their meeting at that time. And then if Mr. Matthews wants to go in front of the county commission, he can, but we need to reflect the board's position that those meeting minutes are inaccurate. And let's move forward.
Okay.
And I make that the form of a motion.
Is there a second to that motion?
A second.
Is there discussion of that motion? Mr. Ragsdale, do we need to, do we have what Mr. Jackson said? Do we need to make that more formal, or are those bullet points something that we can put in a letter to the county commission as they are?
If we could, I would like to hear that again and
Sure.
Yes.
What I'd like to say to the county commission is that our meeting minutes relative to the Barrettville case, when they were asking for a variance, are inaccurate, and that we are in the process as a board of rehearing that and correcting it. And we wanted them to know for their records that our meeting minutes are inaccurate.
And give them the, if I can add to it.
Yes, sir, go ahead.
The date of our next meeting where we're making this resolution, then we're going to, I think we're still going to hold this, correct?
That's correct, yes,
Okay.
sir.
And I would defer to Mr. Rowling. Is that something we can do?
Yes, we can. There's two things that you need to vote to approve that.
Sure.
Second, someone besides me or Mr. Ragsdale needs to review that letter, Mr. Chairman. Obviously, you're the obvious candidate.
Yeah, I'll review the letter. And I'll pass that to the members as well when I get a copy of it. When is that meeting, the commission meeting?
May 9.
Okay, that's right. Okay. Very good. So any other discussion on the motion to send notice to the county commission? All right, all those in favor signify by saying aye.
Aye.
Any opposed? Hearing none. And do we also have a motion to hold this case
So
as
moved.
previously discussed?
Second.
Right. Any discussion? So if this comes back before us, what I think I would like to see, this is my thoughts. I know you've already prepared something, Mr. Matthews. I'd love for the applicant to prepare their rebuttal to that if they so choose. And then I'd like us to get those along with Mr. Matthews' transcripts and a copy of the, a link to the recording so we can kind of go along ourselves as we review those on our own before the meeting. Any other thoughts before we vote on that? Hearing none, I assume you're ready to vote. So all those in favor signify by saying aye. Aye. Any opposed? Hearing none, the motion to hold carries. All right, thank you, Mr. Matthews. All right, Mr. Ragsdale. Let's just see. We're still getting started, so let's see what's going on here. Do we have a secretary's report for this month?
We do not, and I will proceed with the procedures for the meeting.
Okay, thank you.
Thank you. The procedure for this meeting will be as follows. I'll introduce each case as listed on the agenda. Copies of the agenda are found on the front left podium, right podium, I'm sorry. For each case, the planner with the Division of Planning Development will give a presentation that will contain site plans, photographs, and maps of the subject property. At the conclusion of the staff's presentation, the applicant will present his or her case. After the applicant's presentation, the board will hear first from those speakers in support of the application, and then from those speakers in opposition to the application, and then finally, the applicant will have an opportunity to provide rebuttal. All parties who wish to provide testimony to the board will be sworn in by the chairman. If a member of the audience wishes to provide testimony in support or in opposition to a particular case on today's agenda, he or she will need to fill out a speaker's card for the record. Speaker's cards are available at the front podium. Once filled out, speaker's cards can be submitted to any DPD staff member at the left podium. We do not need speaker's cards from the applicants since their names are already part of the record. After all parties have been heard, the board will close the public hearing, make a motion, and then deliberate on the case. Pursuant to the board's rules of procedure, the time allotted for speakers will be as follows. The applicant has 5 minutes to present his or her case. The applicant may reserve unused time for his or her rebuttal. Those speakers in support of the application have 5 minutes. This 5 minutes is the total time allotted for support testimony, regardless of the number of speakers. Those speaking in opposition to the application will have 10 minutes. This 10 minutes is the total time allotted for opposition testimony, regardless of the number of speakers. The applicant has 2 minutes for rebuttal in addition to any unused time for his or her presentation time. These times do not include time for questions from and answers to the members of the board. The chairman may provide additional time provided both sides are given an equal amount of additional time. If the applicant or any speaker would like to be heard after the conclusion of the public hearing, or if a board member wishes to hear additional testimony from any party, a 2/3 vote is required to reopen the public hearing, pursuant to the board's rules and procedures. Please note that once a public hearing is reopened, both the applicant and opposition will be allowed to provide additional testimony and or rebuttal. All motions made by this board will be made in the affirmative. The private acts governing the board require the affirmative vote of at least 5 members to approve an application, regardless of the number of board members present. The board may also vote to hold an application for a period not to exceed 90 days with the consent of the applicant or 30 days without the consent of the applicant. All section numbers that we refer to come from Memphis and Shelby County Unified Development Code, or the UDC, which was adopted by the Memphis City Council and Shelby County Board of Commissioners in August of 2010 and became effective on January 1st, 2011. I'll learn to introduce the entire UDC and make it part of today's record, thus dispensing with the reading of individual sections. The board is vested with the power to act on these cases before us today under the provisions of Chapter 9.22 of the UDC. Mr. Chairman, I submit that all cases have been filed in proper order, all applicants have been notified of this hearing, and all notice requirements have been fulfilled as required by the UDC.
All right, thank you, Mr. Secretary. At this point, the board will establish a consent agenda. To establish the consent agenda, the Secretary will call out each eligible case. If any member of the audience, staff, or board member objects to that case being placed on the consent agenda, he or she should do so by a show of hands when the Secretary reads that case. Once the consent agenda is established, the board will vote on all cases placed on the consent agenda as a whole and will not hold individual public hearings on each case. Mr. Secretary, which items on our agenda this month are eligible to be placed on consent?
Yes, Mr. Chairman. Item number 2, BOA 22-018-2471 Mount Moriah Road. Item number 3, BOA 22-021, the parcel south of 5359 Winchester Road, and that's a hold. Consent is hold. Item number 4, BOA 22-027, 3128 Ashwood Street. Item number 5, BOA 22-0.
Hold on one second, Mr. Jackson.
I'd like to hear number 5.
Number 5, okay. Item number 6, BOA 22-029, 643 Patterson Street. Item number 7, BOA 22-030, 9610 Osborne Road. That's a hold for 1 month. Item number 8, BOA 22-031, 3760 Covington Pike, hold for 1 month. Item number 9, BOA 22.
We're going to hear number 9 as well.
Hear number 9?
Yes.
Item number 10, BOA 22-033, 0 and 1385 Lamar Avenue, with a friendly amendment to strike condition number 2. Item number 12, BOA 22-035, 524 McElroy Street. Item number 13, BOA 22-037, 3619 Marion Avenue. Item number 15, BOA 22-039, 1979 Felix Avenue. Item number 16, BOA 22-040, 999 Oak Haven Road. Item number 17, BOA 22-041, 587 Houston Street. Item number 18, BOA 22-042, 1625 Union Avenue as a 1 month hold. Item number 19, BOA 22-045, 688 Avon Road. And item number 20, BOA 22-047, 8797 Millington Arlington Road, and that's a hold for 1 month.
Okay. Thank you, Mr. Secretary. If we could get a motion to approve on our consent agenda, agenda items number 2, 3 as a hold, 4, 6, 7 as a hold, 8 as a hold, 10, 12, 13, 15, 16, 17, 18 as a hold, 19, and 20 as a hold. And then, I'm sorry, there was one that had the friendly amendment to it. Do I need to mention that? That was number
10.
Number 10, as with the taking out, what, condition 2, I think is what you said?
That's correct.
Is there a motion?
So move.
Second. Moved and seconded. Is there any discussion?
Yes. I'd like to recuse myself from number 10, please.
Okay. Okay, so I would want to remind the board that by voting on the consent agenda, he or she affirms that he or she has read the staff report and is in full agreement with the conditions. Mr. Secretary, may I get a roll call, please?
Yes, sir. Ms. Scurlock?
Yes.
Mr. Milagro?
Yes.
Mr. Jackson?
Yes.
Ms. Goss?
Yes.
Mr. Claybrook?
Yes.
Ms. Baker?
Yes.
Vice Chair Savage Towns?
Yes, I find that the standards of the UDC of 9.22.6 are being met and will not be unduly detrimental to the properties in the vicinity.
And Chair Rainey?
Yes.
Motion carries.
All right, thank you very much. If you are here for any of those cases, then you have been approved or held as requested. Mr. Ragsdale, will you call our first case that we're going to hear today?
Sir, we have agenda item number 1, BOA 21-163, 562 South Edgewood Street.
So this is, Mr. This is a total rehearing, so the applicant's back to being the applicant, opposition's opposition, correct?
Correct.
Okay, so I see the applicants here, and I know we have some opposition, as far as I get straight over here. Let's see, one more second. Ms. Tesel, if you'll give us we've heard this before, and you can if you want to give us an update of the staff report, and then we'll go into the hearing part, if there is an update.
Thank you, Mr. Chairman. Aisha Penzas, Division of Planning and Development. We heard this rehearing last month for BOA 2021-163. So the update that for this month is that we have updated plans and renderings that we received April 25th. And those were not included in the staff report, but they are included in your packets today. And there is an email that I included in my staff report on page 7, which actually summarizes all the updates that we received. To go over very shortly, the applicant removed 2 bedrooms and 1 bathroom from each unit. So now we have 3 bedrooms, 1 study, and 2.5 bathrooms on each unit of the duplex. So the total square footage of each unit were reduced. An 8 feet deep front porch was added to the front facade of the front unit, and the main entrance of this front unit has been oriented towards the street. The roof line is also modified to 1.5-story design, and the height of the structure was reduced to 29 feet. And Ms. Solomito also confirmed that there will be a 5 feet wide grass strip along the south property line that separate the proposed driveway and the property line. And this sums up kind of the gist of it, the updates that we got.
Okay.
Mr. Chairman,
Yes, ma'am.
may I ask the staff a question?
Yes, ma'am.
And also, Mr. Ragsdale, I didn't get a hard copy packet, so I don't have the hard copy of the updates. But here's my question. I'm assuming from your comments and what you're showing that the changes were all in the structure. The site plan remains the same.
Site plan is very similar, but the changes are we added a front porch here. The driveway, the location of the driveway remains the same. The main entrance of the front unit now faces the street. And
Okay, so that's the
setbacks-
updated site plan there?
Yes, ma'am.
And we have it in our packets.
Yes, if you require it.
I think Mr. Malazri is sharing with me. That'll be fine. Thank you.
Thank you.
Any other questions of staff? All right, so I misspoke earlier. The applicant actually is Vicki Loveland, the way it's written up, so we'll go to then we'll go back and forth, but it's still 10 minutes each. So, Ms. Loveland, if you'll come forward and give your name and address for the record.
My name is Vicki Loveland. I'm at 2276 Edgewood Cove, Memphis 38104.
All right, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead.
I would actually like to bring my neighbor up to speak first, if that's all right.
Sure, yeah.
Patty McLean.
And if you have a couple people that are speaking, I can swear them all in at once
Okay.
to save a little. If
We
you
do,
know there's
actually.
going to be, if y'all had like
Yeah,
two or
we
three.
have three
Okay, perfect.
together.
All right, so if you'll go ahead and say your name and address for the record, and then we'll have him do the same. Yes, ma'am.
Patricia McLean, 553 South Edgewood Street.
Okay, yes, sir. And if you'll move over just a hair so we can hear in the microphone.
David Bobby, 208 South Edgewood, Memphis, Tennessee, 38104.
Okay, very good. And do we have one more that's,
Yeah.
If there is time.
Yeah, go ahead.
I will speak. Gordon Alexander, 179 South Remembrance Street.
okay, so
I speak, however.
do y'all swear to tell the truth, the whole truth, and nothing but the truth? We lost one.
Yes, we do.
He left. Well, he's not sworn in, so we'll figure that out. Okay, go ahead, ma'am.
Ready?
I'll get you when you talk. Yeah, sorry. Okay, go ahead.
On March 23rd, the board held this for a 30-day discovery process. The board's current concerns were many. 2-scale site plans, contextual infill aspects, housing types, the neighborhood, UDC codes, form-based codes, building envelope, parking concerns, patterns of development in the neighborhood, currently and past, SERPA working with the neighbors, the intent of use, who is the customer. Has SERPA Construction satisfied all your questions with their revised plan submitted before you today? I implore you to study the numbers. Is this really smaller? Our neighbors have submitted numerous detailed information to the staff report that clearly cites code pertaining to the standards for new construction in RU1. The research thorough and
complete. If I may ask, would the neighbors in opposition please stand with me? Our Midtown neighbors and myself strongly urge the board to reject the 1-foot variance sought by Serpa Construction. Thank you. I move my time to Vicki.
Okay, are there any questions for our last speaker? All right, thank you, ma'am. All right, Ms. Loveland.
Before, I put together about a 1 minute, 40-second statement that I wanted to make to you today. But something happened it was less than 2 hours before this hearing that came to my attention. With regards to these new plans, before we ever got the staff report, I had gotten in touch with Asa and asked her if she had gotten any new plans submitted to her yet. And she said, no, I haven't, but by the staff report, you'll get what you get. And so I got those plans and I looked and they were completely inadequate. They were incomplete, they were contradictory. So I wrote Asa another email, I believe it was Monday, and asked had she gotten any more thorough plans. She said she had not. So I sent that email to Miss Solomita Basir and asked her if she had complete plans yet, that we would like to see them, particularly the rear elevation. She sent me an incomplete 3D drawing that wasn't even of the full rear elevation of what this place was supposed to look like. However, today, when I was just getting ready to get in the shower to come here, I got an email from Gordon Alexander. It was a forward of an email from Brenda Solomita Basir that said, and I will read it to you. Pardon me. It says, hey, Gordon, I am so sorry. I meant to send this to you yesterday, but here are the revisions as directed by DPD. Let me know if you are okay with these. She didn't send them to me, even though I fully requested them. I'm not sure why this happened, why she sent them to Gordon. She knows that Gordon's in opposition, obviously. I don't know what this is, but to me, I should thank her for doing it because it's a perfect example of the subversive way that they have handled our neighborhood, not communicating with us, trying to keep us in the dark and off balance till the very last minute, till they had to submit things to us. There's no way that we had time to look at these full plans. We didn't know dimensions or anything until less than 2 hours before this hearing. And I scuttled to get it to my friends here today that are speaking as well. On that, I'll go ahead and read what I had written because it pretty much still applies. The new plans submitted by Mr. Serpa still do not comply with the UDC or contextual infill standards, and they fail with the changes requested by the board at the last hearing. These new plans may eliminate 2 bedrooms per side, as well as the balconies and terraces, but this structure still remains a massive overbuild for this lot. It's over 5,400 square feet, and with a capacity of 8 bedrooms. Again, they've got that study with the closet. It can be a bedroom. And the parking, they haven't addressed that at all. The parking is still inadequate with 8 bedrooms. These plans are still more conducive to housing for college students and short-term transient renters, and they simply don't comply with code. Unit 1 now has a street-facing entrance with a porch, but there's an obvious contradiction in their rendering of Unit 2. This unit is still sideways on the lot and faces south. It is not street-facing, and code dictates that it should be. There are no other homes on the block that do not face the street. Also, the 2 garages are now crammed in between the 2 units. Those garages have a whole lot of space above them, and there's no indication of the intent for that space. Is it strictly attic space, or can it later be converted to another bed and/or bath? It certainly begs the question, but we've had no way of knowing until they submitted these plans to Gordon, not us. In addition, these new plans don't show what we saw before today, we didn't have any driveway or site plan dimensions, and no way did what we have represent a complete building envelope as the board had requested. at the last hearing. This plan does not comply with the UDC. You have 95 letters of opposition in front of you. It's plain and simple. It is not suitable for this neighborhood, and it should be rejected flatly. Thank you.
Are there any questions for Ms. Loveland? All right, none. Thank you.
Thank you.
All right, well, we still have time we have 3 minutes, 15 seconds. Anybody else want to speak? Okay, so we're moving on to the opposition. Ms. Holman-Baser, you could give your name and address for the record.
Thank you, Mr. Chairman. Brenda Salamito Baser, Salamito Land Planning, 1779 Kirby Parkway, Memphis.
All right, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead.
All right, thank you. And as a result of our last meeting, within this 30 days, there has been almost a complete and total redesign of the project, taking into consideration the neighbors' concerns and also comments from the board. First of all, we'll say that the structure itself per unit was reduced by 1,100 square feet. So it was a 3,800 square foot unit reduced down to 2,700 square feet. Removed 2 bedrooms and a bathroom per unit. The green space now on the property is now at 40%. He removed all the balconies and terraces as requested. He relocated the garages to the center part to optimize open space and produce less asphalt. Now the facade of the building faces the street and is in character with the other homes on the street. It has a front porch and also has the driveway width reduced to provide the 5 feet of landscaping on the adjacent property side. The ground floor elevation is set a minimum of 18 inches above grade, as per the standards in the UDC. Interior renovations, first floor ceiling height is 10 feet, second floor is 9 feet. The design appears to be a 1 to 1.5 story to also blend in with the character of the neighborhood. The overall height is only 29 feet, whereas the district standards allow for 35. So again, it is also comparable to all the other structures in the neighborhood. It matches the front setbacks, which are part of the contextual infill standards. So in listening to some of the applicants' accusations, I'm not sure I understand, nor am I sure that I agree with a lot of the statements that were made. It appears as though these statements are prejudicial against Mr. Serpa and renters, whether it be a family of 4 or whether it be someone who is in school. I think all of us have been renters at one time. But it does appear as though this redesign, with the guidance of DPD staff and Mr. Ragsdale, we believe we have met all the infill and contextual infill requirements. We have looked at the construction costs, and this will be somewhere between $160 to $200 a square foot in construction costs. So this is not going to be an adequate product. And if we want to talk about some of the other factors, Amanda, if you could keep going down just a couple more slides to this is the drainage. So again, revisited some of this with the civil engineer, Mr. David Bray, on how to accommodate the drainage that is coming onto us from the adjacent properties, which again, according to state law, is illegal. So Mr. Serpa is dealing with this existing condition so that it does go, and it will be graded or piped so that it actually flows towards Edgewood. Next slide, please. these were some of the other issues that we discussed prior to the first meeting. And regardless of emails that were sent here or there, I sent everything I had at the time. I coordinated flawlessly with the Division of Planning and Development. And I was able to get plans out to whoever I was able to at the time that I had. Again, this was a total redesign of this project within the 30-day capacity to be able to come back here and to do what was asked of us. We also looked at, go down the next slide, the existing housing pattern in the neighborhood. You have triplexes in this within the block just to the west. You have duplexes. You have townhouses, which are some are rental. You have some condominiums, which are for sale. You have a lot of rental properties in this neighborhood. So singling out Mr. Serpa for building a duplex on what is an unusual lot. This is not a standard lot. It is an exceptionally long lot. And that's the practical difficulty of this application. And that's why we are asking for a 1-foot front property line modification. It was platted many years ago as 49 feet. That is not something that Mr. Serpa did, or when he purchased it, it was an existing 49-foot lot dimension. He could build a single-family home the exact same size or bigger today without any permissions from neighbors or this board. If he just follows the zoning criteria of this zoning district, it could be one house, 35 feet, 6,000 square feet. So we're here respectfully requesting your support and Mr. Alfredo Serpa's efforts in totally redesigning the project, try to be accommodating so that it will be compatible with the neighborhood. Mr. Serpa is here. I'm happy to answer any questions that you may have. Thank you.
All right, thank you. Are there any questions for Ms. Solomito? Mr. Jackson?
Ms. Solomito? Can you tell me, I'm looking at these drawings, but can you tell me what is the overall length from the outer face of the building to the outer end of it? I think that's an east-west direction, I believe. Yeah, can you give me that dimension? Because I don't see it.
The overall length of the entire building.
Is it shown on the drawing?
Yeah, this.
Let me go ahead and name and address for the record.
Alfredo Serpa, 4541 Chickasaw Road, Memphis, Tennessee.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, go ahead.
We have a 20 feet front setback and 20 feet back setbacks. So the lot is 190, so the length is 150.
So from one end of the building to the other is 150 continuous feet?
Yes.
Thank you.
The garage were initially outside, and now they were centered in the middle, so we could increase the grass area that could be kind of the front for the front unit. And then also, the garage stay on the center, we could reduce the driveway and we'd increase a lot more grass and green area for the back unit.
Yes, but the total length of the building is 150 feet?
Yes.
Thank you.
And what's the setback from Edgewood?
The setback on...
Yeah, how far is it off of Edgewood?
20.
20, okay. So the backyard's roughly 30 feet of grass behind the building?
It's going to be 20 and...
20 plus 150 is 170. It's a 200-foot lot, roughly. 197, I think.
Yes.
Okay, all right. Other questions for the applicant? Okay, yeah.
Oh, I can
yeah, go ahead.
Resume something with the changes. Initially, the build was massive. It was 2 stories, really wide, really big, and then I went down on almost 1,100 square foot between balconies, open areas, and all of that because it was kind of massive. So we did reduce with going 1.5 story. Also, the square footage on the second floor were smaller. And the bottom, we only have the master bedroom with living room and kitchen, and then we add the balcony now as requested. So we did accommodate it and reduce a lot of what we have originally based on neighborhood and the board suggestions. And the green space, I guess that was kind of something important, moving the garages, make it have a more grass area on the unit. Yeah, besides that it's a lot smaller with what we have originally. That's it.
Okay. Are there any questions for Mr. Serpa? Hearing none? All right. Thank you all very much. How much time do we have left? The 2 plus the
5:16.
Okay. We have roughly 5 minutes left for rebuttal. And then now let me hear your name and address for the record. I don't think I ever swear.
Bobby, 208 South Edgewood Street, Memphis 38104.
Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? All right. Go ahead, sir.
I've been a homeowner on South Edgewood Street for 17 years, a resident of the Midtown area for 33 years, and I fully understand and appreciate the unique residential character of the surrounding area. The pattern of development in the last 20 years for the block face and adjacent neighborhood areas has been new, single-family, owner-occupied residences, fully code compliant and without variance, with front and rear yards and large front porches, some with garages, everything street-facing according to code. I own a home just north of the proposed project that was a tear-down and rebuild on a similar size lot. There are no duplexes on South Edgewood Street from Vinton north to Union Avenue, although there may be some streets over. There has been no duplex construction in the block face for more than 20 plus years. Data submitted for staff report indicates 19 duplexes in the block face, 3 built and permitted legally, and 16 others by conversion. Duplexes in the block face comprise less than 16% of the housing type in the area. Single-family residents are the majority. Although zoning allows duplexes as a permitted use, a duplex in this area would be contrary to contextual infill standards by violating the established neighborhood traditional character and stability. This housing type is not needed here, particularly with short-term rental, as Mr. Serpa has requested. There will be no way to monitor and control who comes and goes or what is brought with them. A duplex here is not properly related to the surrounding development patterns. Single-family residences. There have been 7 single-family residences constructed in the area, all code compliant. In the block face and surrounding area, there are no structures with 8 and potentially more bedrooms, 4 to 5 bathrooms, 4-car garages, or size that exceeds 2,500 square feet on similar size lots. Each of his units exceed that. Each. Mr. Serpa claims substandard lot width as a hardship for his intended purpose. His hardships of his own making are lacking sound judgment and lacking proper due diligence for buying a property without a survey and as is. His prior inquiries for use was subdivision, which the LUCD rejected, then condominiums, and now he's asking for a variance to construct duplexes that is overbuild and still not code compliant. The second unit is not front-facing. The garages are not front-facing, contrary to the examples shown in the UDC. Everyone has heard the phrase, cramming 10 pounds into a 5-pound sack. This is what's going on. Another hardship for him is to figure out what he can develop there. However, he can develop the property in another manner that does not require variance. Profitability on a development is not to be a reason for granting variance per UDC. Mr. Serpa did tell concerned neighbors on site in February, his only connection with the neighbors, that I need to maximize my use of space for maximum profit. There it is. Mr. Serpa would like to build, sell, maximize his profits, and take the money and run, leaving the consequences to the neighborhood. Those consequences would be decreased property values, instability, parking congestion, damaged neighborhood character, and increase of transients. In January, the board instructed Mr. Serpa to submit revised floor plans and elevations that meet the contextual infill standards for approval. He has made some revisions, and we acknowledge that. Downsized, the outside has been modified, but the footprint is still the same on the ground floor. He has made some revisions submitted through Solomito Land Planning to you all that exhibit an ongoing pattern of disregard or ignorance of these standards. I don't know if that is from bad advice from his consultant or not accepting advice or obstinance, but they still do not comply. Not one of you, not even Ms. Baser, would want what is proposed jammed next to your home or in your neighborhood. Ms. Baser is being paid to say that this project is appropriate here. It's not appropriate on Walnut Grove Road, on Higbee Avenue, on Chickasaw Road, or in Glenview Heights. I don't know any Midtown neighborhood where the proposed is appropriate. Opposition to this project with plans submitted is not just about a 1-foot variance. It's about the housing type and the many things that are still not compliant with UDC. Contextual
Okay, that was our timer, sir. Are there any questions for the Mr. Bubby?
Yes.
That's okay. Just okay.
I have a question.
Yeah, go ahead.
Never mind. Go ahead.
Well, I see here that the builder. I'm sorry, I messed up the name, but he addressed some of the concerns with the front facing, the facade facing the street, the adding the front porch, I was taking some notes, reducing the roof line, and so on, which was some of the concerns that were mentioned in the last meeting. However, just devil's advocate, I'd be curious to know if this was a single family development, would it make a difference?
Probably, perhaps only on size.
But, I mean, given the size of this, if it was a single family development at this size, the way it is, would it make a difference?
Oh, the overall, what he has said to you is that if I didn't get the variance and I built a single family home, and Ms. Baser said it, he could build a 6,000 square foot home. That's still, in all of our mind, overbuild, because all the new stuff that has been built in the last 20 years has been under 2,500 square feet, although we would not object to a larger home.
If it was single family?
As long as it fit the traditional character of the neighborhood. We don't have an issue with that.
And they did address parking on here as well.
Parking is a serious issue.
But they did address parking on this new, have you, this one here? Because there's 4 bedrooms, and there's 2 car garages, and then space for some overflow. And I think, what is the ratio, 1-to-1 for bedrooms?
Well, the parking requirement for duplexes is very similar to single-family homes. And 2 parking spaces on site is required for more than 2-bedroom structures. So I would say they have already provided 2 parking spaces for each unit. And if we count the driveway itself, they're exceeding that 2 parking minimum requirement right now.
Single car driveway.
But it's they're 2-car garages though.
Yeah.
And they are still not street facing for representation in the code. The second unit,
the facade is street
facing.
right? That's how it is.
Why
Okay.
should they be given an exception to that?
Okay,
Well,
hold on.
My other question.
Go ahead.
Okay, go ahead.
Did you go ahead?
So my other question would be, what would be acceptable? I mean, I'm just trying, our job is to think in terms of solutions. So what is acceptable? They've done made the adjustments here, and it still doesn't appear to be acceptable, but what would be acceptable?
It's still not totally acceptable to us, but it's still not compliant with UDC.
It's an overbuild for the lot.
Which is why they
Okay,
asked for a
just-
variance,
it's
so what would be
150 feet
acceptable?
long
That never changed.
with a 20-foot setback, and there's supposedly 20 feet on the back. It doesn't add up. The lot's 188 feet long.
Mm-hmm. Well, people ask for variances all the time. That's why they come here. So that's why I'm asking what makes sense to you.
Within code, whatever, even, a single-family home could be built there without a variance being granted.
So a single-family home of this
and
size.
also, the 6-month lease that they have on these, that's short-term. I mean, I don't know if that's actually legally considered short-term, but it's perfect for college students. It's perfect for people that don't have any investment in the neighborhood who are going to move to something else soon. The parking issue is you've got a potential for 8 bedrooms in this thing. And again, over the garages, there's space that is not explained. That could be converted to another bedroom, another bath in the future after he's made his money and gone. And what control are we going to have over that? Our neighborhood is a narrow street anyway. There are no other duplexes on South Edgewood. And that's what I'm trying to stress here too. And this is a massive overbuild. There's no 2,700 square foot houses, single family homes on that lot. This is 2 of them smacked right up together. And it's not adequate parking.
Ms. Doss, to address your question, as I said, I have a rebuild on a house that was torn down just up the street on a 50-foot wide by 193-foot deep lot. I have just less than 2,000 square feet, and it's a beautiful home. But I wouldn't have any objection if somebody wanted to go upstairs with it and make it a 4,000 square foot home, or maybe even a little bigger. I would, if it wasn't already built, I might have done that. And that's appropriate for the neighborhood. We have centennial homes here. There's several that are 100 years or more old. We have plenty of school that are outside of the block face, but everything's in character. Everything is street facing. Garages, if they're there, they're street facing. Front porches are large. They're street facing.
And again, it's mostly owner occupied. Everything, even the planned development that I live in, Lennox Townhome South, we are in our covenants and our bylaws owner occupied. We have 2 residences that rent. They're grandfathered in, and they've both been in each of those units over a decade. They want to buy their units. This is the character of our neighborhood. We have children riding their bikes up and down that street. We have people pushing baby strollers. This is a quiet, small neighborhood. We're surrounded by all this other growth that's going on downtown. I mean, there's plenty of housing available for renters.
And this is the only lot left on the street.
Okay.
So let's.
And it would set a bad precedent. It would tip things in the wrong direction.
All right, Ms. Baker, did you have another question?
I did,
Yeah, let's
Mr.
go ahead
Chairman.
with your question.
Thank you. My question was, what's your name, the gentleman?
David Bobby.
David Bobby, yes.
It's not spelled like you say it, but anyway.
Okay. Well, I took from all of the information that you were given that you went around and surveyed the duplexes and the triplexes and all that you find in the neighborhood. Did you do that?
Another neighbor that's not in attendance did.
Okay.
She gathered the housing type information that Mr. Jackson asked staff to provide, and I don't know if they ever did.
Okay, so maybe
124 single-family home structures, 19 of which are duplexes.
So maybe, however, although you did not do the survey, you still may be able to answer my question. which is of those duplexes that are in the neighborhood, are there any of them that are, have one of the units in the backyard like this one does?
I don't believe so.
Okay, that was a question I had.
But
There's nothing like what they're proposing.
Okay, Mr. Jackson, did you have a question?
Yes, sir, Mr. Chairman, thank you. If this was a single-family residential home built like it is now, would it be acceptable to the neighborhood?
No.
Yes or no?
No.
Size.
Thank you.
It's overwhelming for the lot. And
Okay,
you all
okay,
are
yeah,
aware
thank
of the
you.
drainage issues.
Thank you.
Okay.
The drainage issue can be addressed, so.
To the side.
Are there any other questions? All right, then I would like to see if anybody would like to.
Thank you for your
Mr.
time.
Yeah, thank y'all. Mr. Ragsdale, I want to make sure, we always make our motion in the affirmative, but our applicant was the person that did not want the thing, so I'm looking for the proper motion to approve the variances. Would it just, is it just a?
Yeah, let me check real quick.
Okay,
Yeah,
just,
but
okay.
Again.
Make sure we know.
It's just like if it was coming before you as a variance request. So a yes vote is to approve the project, and then a no vote is to deny.
So is there a motion to approve BOA 2021-0163 as conditioned by staff?
So moved.
Second. Or is there any discussion? Mr. Jackson.
I have a question for staff. With regards to the neighborhood, out of the townhouse developments that are there, what is the maximum length of any group of connected buildings in that neighborhood? Do you know?
By maximum length, do you mean the street frontage?
Length of building, not street frontage.
Oh.
For instance, if they're turned sideways, what is the maximum length of 3 townhouses or 4 townhouses put together? Do you know?
I don't know. I can't say.
I'm looking around, if I had to say, maybe 50 feet without a little break in between. Just looking at least at the one next door.
Okay.
Just estimating.
Thank you.
Please, we're done with discussion on that, but thank you though. Like I know you were just trying to be helpful, so I'm not trying to shut you down, but we just are in a different spot. Any other questions?
50 feet is the same as this?
What now?
By eyeballing that,
Okay, so to answer
feet.
his question based on, I have the map pulled up and
Yeah.
kind of see so the townhouses to the north, they have breaks in between, every 3 to 4. So maybe 50 feet is my guess. It's maybe a third of this length, maybe longer, but not 150 feet.
But they're not, they don't have garages or any, no.
No, they're just straight, just driveway up to the front of those particular ones that
So
I'm
if
looking
he
at.
separated the house, made 2 houses, that a possibility?
That would be a PD.
OPD?
I think it would be a PD, like they would have to do a subdivision to put 2 houses
Oh,
on
a
it.
PD. I
Yeah,
got you.
sorry. Mr. Jackson?
Another question for staff. Can you tell me, and I thought I overheard in the presentation or in someone's response, that there had been other applications applied for on this property by the present proposer? Is that true? Was it for condominiums or something?
I believe we received an ASBR application for the same property in September 2021. But that was an application that was filed in error. ASBRs are not required for single-family projects. So other than that, I didn't see any other applications filed for this property specifically.
Mr. Ray?
Mr. Jackson, if I may.
No, hold on. Does anybody want to hear any more testimony on this case? No? Okay, thank you. Go ahead, sir.
That's correct. We're not aware of any other applications from this applicant or others for another type of project on this.
Okay, thank you.
I have a question of staff too. So there's been mention of like the renderings in the UDC of what a duplex looks like. Is it against code to have a stacked duplex this way that aren't both front facing? Because we are only approving a variance of 1 foot to allow duplex. We're not approving any other variance, correct?
That's correct.
Okay. Any other questions or discussion?
Are we in discussion?
We are, yes, we are in discussion. Yes, ma'am.
Okay, I'm trying to,
Yeah.
follow. Like
we are in discussion, Ms. Baker.
Yeah. Well, and you know this, I don't really agree that the UDC is not telling us that two-family dwelling should have 2 units that have a front door facing the street and a back door facing the other direction, similar to the homes that are adjacent to them and that are in the neighborhood. And so because of that, I don't think this is just about a 1 foot variance. I think it's a violation of that very basic rule. And I scoured the UDC. I could not find any example anywhere of a unit or a 2-family dwelling where 1 unit faced the street, but the other one was in the backyard. And it puts me in mind of these long, narrow apartment buildings, that in neighborhoods that were zoned multifamily, that they were able to just slide them in there because we didn't have any rules about how they should face. And so if you happen to have a traditional house that was in one of these neighborhoods zoned for, that allowed multifamily, single family, duplex, and so forth, and one of these things got slid in next to your house, well, a home is like, the sidewalk, your neighbor can wave at you, but if they start coming down the front steps and if they get on the front porch, there's a change in privacy. And the backyard is where we all, I think most of us feel like we can go back there and, maybe our neighbors on each side can see us, but, not the whole neighborhood, and certainly not people who are, a number of people who live there on a short-term basis. So I think it is a violation of the housing types. And I think for the description I just gave, and you can see them all over Midtown, and the relationships, the harmful relationships that they set up, I just don't think it's an academic discussion. I think it's real. And I think it will affect the home next door. And so I'm going to vote against this because it may be a complete redesign, but it didn't change that one feature that, in my opinion, is the one that's really important and the one that really makes a difference in terms of how that home next door is affected. And I'll just say one other thing. I said I was through, but I was going to say one other thing, that those townhouses, they set up this site as a kind of a tough site, really. But, that was done before the Unified Development Code was adopted. And like I say, I think one of the good things about the Unified Development Code and the form-based aspects of it is that it addresses not just the land use and the building size and the height and so forth, but goes to those important relationships of the pattern of the neighborhood. So that's it. That's.
Can I ask you? So
yes.
One, I did measure the buildings to the east of this that are kind of down the little cove, they're 100 feet wide. Yeah, and I use a little measuring tool. I just want to understand what you were saying. So you scoured this UDC. You never necessarily found anything written that said how a duplex should be, but just based on every example of it was always side by side.
And facing the street.
Okay, I just wanted to make, okay. All right, Mr. Jackson.
The contextual development of a neighborhood, and I've done a lot of master plans of residential communities throughout the Southeast. If I was designing this from scratch, this would be the oddball scenario in the plan. It does not have the contextual sense of fit that it should have in context with the others around it. It's so different in the fact, as Ms. Baker pointed out to us, that you've got one facing the street, you got somebody living in the rear quarters. And that's not the context of which this neighborhood sets within, one. Two, 150 linear feet of building is an apartment complex by no matter how you stretch it when you look at it in its context. I don't care how many units are in it, that's 150 linear feet. I want you to understand 150 linear feet is half the length of a football field. That's pretty long. And the opposition from the neighborhood is no different than what we had at St. Jude when they wanted to build a parking garage. The neighborhood's not for it, it's out of context, it just doesn't fit the way it's designed. And it does have the capability, although the bedrooms have been removed, for those units above the garage to later be built out. I'm going to vote no. I think Ms. Baker is on the right track, and that's it. Thanks, Mr. Chairman.
Other thoughts?
I do think it is a bit oversized. I'm in alignment there, and I'm going to borrow your delivery, John. Mr. Chairman, what gives me heartburn? Is that good? Close?
It's close.
What gives me heartburn is that we have approved some weird stuff, right? Like, there's been some weird stuff that's been allowed to be pushed through. Like those houses on Cooper that are stacked weird right off Southern, they're right behind one another, right? Then that monster house on McLean, and I believe it was Harvard. It's way too big for the lot, but it was approved nonetheless. So there's some weird houses on Cooper that are stacked up together that have been approved. There's a monster size house too big for the lot on McLean and Harvard that's been approved. So that's where I'm really struggling with, okay, there's been some weird stuff that's gotten pushed through. So I struggle with that a little bit. I do want this gentleman to be able to, develop the lot that he's purchased. And I do, regardless of profit or whatever, however he sets it up, we can't control who lives there. But I'm weighing that. I'm thinking about that part, but I'm also thinking about, it is a little bit too big. So I'm kind of going back and forth between those two things.
Go ahead, Vice Chair.
Okay, I think I'm going to be the, opposition to the board. I think they have put in a lot of work, and I'm just going on the view I can see from Edgewood. We do have the duplexes that are on one side, and we do have a traditional home. I think the way that they have creatively adjusted the plans kind of compromises the view on, if I'm looking at the properties straight ahead, duplexes, a townhouse on one end, traditional home, and they've combined the two. I think they make, to me, this is just my personal, best efforts of the property in developing it. Moving the parking, the garages in the center, gives it a lot of length, that's of concern, but they did move it from on the outskirts, which was a concern about pulling in, pulling out. I think they really paid attention to detail of the concerns of the opposition and the board.
And they took the notes.
And made some major steps in trying to develop that. I do have issue when people speak about renters because people have to start from somewhere. And I do, we all have rented, we all have been in college and didn't tear up homes and didn't depreciate the value. So I do have an issue with that statement. But at the same time, I think, they have made a good faith effort in building a nice structure that wouldn't turn into some type of bad property because of whether they sell it, lease it, or rent it. No short-term rentals, probably not, and I think we can condition that if that should ever pass, that it, sustains some long-term value. But at the same time, I think they really put in good faith effort. I think they listened to the comments of the board and the opposition the last time. So that's just my 2 cents on that.
Mr. Jackson.
Mr. Claybrook, I'd like to hear from you on this because I understand your development background, and I'd like to hear your opinion, please.
Yeah, I'm kind of torn on this one. So I'm with Ms. Savage Towns. When I saw these renderings, they completely redid this. I was born and raised in Midtown, so I spent a lot of time. I don't live there anymore, but this front facade to me looks like a Midtown home. Porch, setback windows, the roof structure looks that way. I think they've done a good job with the green space, as well as tucking the garages in. But I come down to the linear feet of the development, like you spoke about, and how big it is. But then I come out and I pull out at a macro view of the entire neighborhood, and you've got schools that were converted to multifamily residential. You've got multifamily residential directly next door, single family on one side. I think if we are going to move forward, I'd like to put some conditions on it, which I was going to say. One is, it sounds like everybody has a concern about the building out over the garages. I would say that we make that stay attic space forever. I would like to propose, I know we had discussed the past however many meetings we've been working on this, 6 months cap on renting. I would like to bump it to a year. I think that would alleviate some concerns of this being and again, I agree with Ms. Savage Towns. I have been a renter in my life. We all start somewhere. And so those things to me would alleviate some of those concerns, as we move forward and vote.
Yes.
Mr. Cover, I have one more question for you. If you were developing this area and you had that site, would you develop 150 linear foot structure there? To me, it just seems out of context.
Yeah, and as my background, I'm not a residential developer, so.
Commercial.
Well, yes. Again, I'd have to look at the numbers. I know we're not supposed to take that in consideration up here with our votes, but if I was the applicant and I look at this lot, if I look at a single family home, if I'm developing that and look at the comps, what it's going to sell for, what is my margin there? And likewise with this. I mean, I get he's probably trying to maximize, what he can build here if he's going to be renting it. 2's better than 1 if you're going to be renting it, obviously. So the answer to your question is probably not, but I can't say that for sure without really peeling the onion open and looking at every aspect of it.
Thanks for letting me put you on the spot.
Yeah, no problem.
Other thoughts, comments?
So, to my fellow board members, I mean, is there a way that we can condition this to reduce the length of the building. As it seems like that seems to be the biggest contention of how this structure fits into the lot.
Well, we have to take off, what, 50 feet? At least?
I mean, you're looking mainly at the garages is what it's really making the length, and how do
That
those...
impacts the parking.
And then that, correct. Then it affects
I think if you change the length of it, then you can't do a duplex. Like, I mean, it's just like, just vote no. You know, that's what I would think. Yeah. The length doesn't bother me as much, because it was all, I mean, like the street frontage is right there. You got the neighbor that it touches the most is not 150 feet, but it's, two 60-foot buildings with a 20-foot gap in the middle. It's not like it's little one bed, house with a space, and a house with a space, house with a space. They're all joined together too. I don't know that I'm concerned with that so much, but anybody's right to be concerned about that. But yeah, I do think if you change the length, just bad idea.
They chopping up.
I mean, I see this as an opportunity where we can still put some conditions on it to take in the concerns of the neighbor, while if we vote no and then they build a single family, they could come back with essentially the same structure, but a single family home. Is that correct, Seth?
They could. Yeah, they could build whatever they wanted to, single family, and use up every bit of this envelope.
Yeah.
Which still wouldn't really fit into the contextual infill of the
Exactly.
neighborhood, but at the same, and we wouldn't have any say in that at all.
No.
Yeah. I mean, if
To me, the contextual infill is the front of it, not the side of it. I mean, me looking at it, when I'm driving by, you might be able to kind of notice it, but what you see is the front that faces the street. It's not like it's along a street in this huge, long, 150-foot building you drive by. You drive by 25 feet of building. And then everywhere else, it's like, a little backyard that can see a piece of a building. So I guess I don't know how to compromise it. But if you have ideas, go for it, and I'll see what I can do to shoot those down.
Mr. Chairman, I also had another question.
Yeah.
And I'm going to lean on Mr. Jackson's expertise for this, but I'm just seeing blank grass here. Is there a way to, I'm assuming there's going to be some sort of landscaping, or if not, can we condition it to something that fits with the, surrounding area?
That'll help with privacy.
Yeah.
Help a little more.
With privacy and
Yeah, I think we'll have to.
visibility.
Can I have one more question?
Yeah, go ahead.
Can somebody tell me what the dimension is, the north-south dimension along the front? Is that 21 feet, 21 feet, 5 inches? What number is that? I know what the word porch is.
Yeah, you're asking the wrong guy. I do agree. I think it's 21. The porch is 21 and something. So it's under 22. It's definitely a 21. Then I guess it's a little bit bigger than that. It's more like 25 when you add that in. If that 23, because it does have a little bit of steps there.
21 feet, 5.5 inches.
Okay.
Yeah, that's what the porch is.
Yeah.
Okay. Thank you. If I may.
Yeah, please do.
I think Mr. Claybrook had some great additions to add on to it if it passes and, can't build out the space. I also think that one of the conditions should probably be along the north property line, which is the backside of the structure. There should be a 5-foot evergreen screen that runs the entire length of that building. On the
5
north
feet,
property line.
5 feet tall, 5 feet wide.
5 feet wide at the base horizontally. And, some type of vertical evergreen should be put in from the front facade all the way to the back rear, so that the size of that structure versus its neighbor to the north is somewhat screened, at least at that level. And it needs to be some type of plant that can get up, 20, 25 feet.
Could you go back to the picture that shows the drainage, that shows the puddles? And then also, does staff remember the setback between the building and the north side? What I'm looking at there, wow, I wanted to see that because they have, the other place is 2 full stories, we're 1.5. They're actually, to the peak of the roof maybe the same, but they actually have more visibility of our lot than we have of theirs. We have 3 windows per unit. They have at least 8 per building.
Yeah.
Just a thought.
Excellent.
I don't know how far they are. Again, I've been using my little measuring tool. They're about 10 feet off the back line. And so I'm curious how we are off the back line.
Was that a question about, you're asking about the?
I would love to know, the setback from the north side.
I believe it's 5 feet.
5 feet, so we're twice as close.
Required side yard setback, yes.
So we have just enough room for your bushes, if they're 5 feet wide.
We got what, 10?
They're about 10 feet from the back, and we're 5 feet.
We're 5, so
We're
we
5
only
feet.
have 5.
Yeah, we only have
So we can't do that, it's not possible.
Yeah.
Draw that as a condition.
Okay. Any other thoughts?
Was it? I'm trying to find the drainage piece.
What are you looking for?
Oh, here we go. Drainage and stuff. Drainage about drain. Oh. Was that language about drainage?
Well, I mean, they have to, as part of the site.
They have to do that.
Yeah.
That was just part of her.
And then,
Lasers.
is there any other discussion? Is there a problem? Somebody mentioned the condition for 12 months rentals.
That's correct. I believe Mr. Claybrook mentioned a couple of conditions, so we need to have that a motion for if you still want to make that motion about not being able to build out the attic space and having the lease be a minimum of 12 months, I believe, but however you want to word that.
Right.
I would say definitely the 12 months. And then, I mean, do we say not building out over the garage, or do we say keep it at an existing 2-bed? I mean, we can't, if somebody converts a dining room into a bedroom or without doing any actual construction.
I would say that you can't build out over the garage.
Yeah,
Would make
I
the
think
most
that's-
sense.
Okay.
As a condition.
I mean, really, truthfully, like that set funny with me too. Like, this is not a low rent neighborhood. The concern is about caliber of renters.
Mm-hmm.
This neighborhood is not low rent. So I think caliber is not an issue. I don't think that's going to be an issue at all, even with students.
Mr. Jackson, do you want to do some sort of landscaping?
I don't think we have the space to do it. We just got 5 foot. I'd like to, but we don't have it.
I don't know. And also, I was just looking at, this, just the grass going up to the.
He's talking about the driveway in front.
Driveway porch or something. I mean.
Yeah, excellent point. I think we should require that a landscape plan be submitted to OPD for approval.
For the west and south sides?
Yes, for the entire site.
Okay. All right.
Thanks, Mr. Clayton.
Any other comments before we vote?
And I want to make sure we get a second, so let me just clarify. We have a motion that includes the conditions that you cannot build out over the garage space, no lease will be less than 12 months, and that a landscape plan be submitted to DPD for review and approval.
Yep.
Okay. I do have one more comment. One thing that Ms. Solomito said that to me wasn't quite accurate, but not necessarily misleading, is that she mentioned this lot was platted years ago. This is actually an unplatted lot, and I do real estate. That's what I do. I'm a real estate attorney, and there's so many lots in Midtown in places where the idea wasn't to have a 49-foot lot. It was supposed to be a 50-foot lot. They just sucked. doing things right back then. They didn't, I mean, like this, so I mean, I kind of go back to this is just, it's just 1 foot is the only thing we're talking about here on a 49-foot lot. And that's what I see being the issue. I'm trying to, and I think they've come back with a better plan that has less windows on the back. It, to me, from the back neighbors, it seems smaller. Whether they think it seems smaller or not, it seems smaller to me. But I just wanted to say that about that 49 feet, we see that a lot, but it wasn't they meant to do 49 feet. They just didn't do things all that well. You know, we have better ways of measuring. We don't drag chains around anymore like we used to, to survey that. So it just kind of happens sometimes. So unless there's any more comments, I assume you're ready to vote. Yeah.
And can we get a second for Mr. Craig?
Who gave us our second? Yeah, I'll second it.
Okay.
Yes.
Ready to
Chips?
vote?
Yeah, let's see where they fly.
Mr. Claybrook?
Yes.
Ms. Doss?
Yes.
Mr. Jackson?
No.
Ms. Skurlock?
Yes.
Mr. Malazri?
Yes.
Ms. Baker?
No.
Ms. Vice Chair Savage Towns?
Yes, I find that the standards of 9.22.6 of the UDC are being met and will not be unduly detrimental to the properties in the vicinity.
And Chair Rankin?
Yes.
Motion carries.
All right. Thank you all for coming down today. Mr. Ragsdale, will you call our next case, please?
Yes, sir. Item number 5, BOA 22-028, 5905 Grosvenor Avenue. And I don't know if I pronounced that correctly. But...
Okay. Is the applicant present? Okay. See, is there any opposition? I know we pulled this. Okay, Mr. Penzis, why don't you give us a super brief staff report, or unless Mr. Jackson had any specific questions, I'll ask him.
I really didn't have a specific question. What I wanted to do was add a condition to the approval of it.
Okay. So why don't we just hold off on the staff report, since we should have read, and let's go straight to you, and then we'll talk to the applicant.
Okay. What I'd like to condition this as, I think we all received some emails of, opposition on this. And there's one that stuck out in my mind, and it was, and I'm not going to call names, but I'll tell you the essence of what it said. They said that the light would be shining in their bedroom at night, and that's an issue, I think, clearly. So my condition, I'd like to add a condition to this. It says at 10 o'clock at night till 6:30 in the morning that the signage goes dark. And the only time it doesn't go dark between 10 p.m. and 6:30 a.m. is if there's an event at the school, and when the event at the school is over, 30 minutes after that, the sign goes dark. That way, if it's an event that night and people are there, they can see whatever's going on. If it goes past 10, on regular nights when there's no event, it cuts off at 10 and comes back on at 6:30 in the morning. And I think that would help the neighborhood, especially if that light is shining in someone's eyes, or even if it has been toned down in its brightness. That's the only one I've got for that one.
This site seemed a little more narrow than some of the schools, and a little more packed into that neighborhood.
It did, yes.
I was already thinking the same thing on that. I was actually one 9. But I didn't think about the 30 minutes in events and stuff. Probably there won't be many events that go up to past 9 o'clock at a school. Yeah. Okay, that's, any other thoughts before we talk to the applicant?
What's the grade level of this school?
I think it's elementary, I believe.
Okay.
Okay. Let's see, where's our
14.
14, thank you. I guess we'll have to ask. Yeah. Okay, is the applicant present to talk to us? Yeah. You can speak in favor of it, or if you just want to give your name and address first.
Jim Williams, 821 Vance Avenue, Memphis, Tennessee.
C38126.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, do you have any comments for us on that, or do you want to give a presentation?
No, sir. Whatever y'all want to do,
Yeah.
I agree.
Okay, then I'll let you, we do have somebody here in opposition.
Okay.
So I'll let you reserve your other 9 minutes and 30 seconds, and we will talk to Mr. Kelly unless somebody else is here in favor of it. If you'll give your name and address for the record, sir.
My name is Michael Kelly. I live at 2535 Lovett Avenue.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, go ahead, sir.
First, I want to thank the committee for the hard work that they do. And it's a thankless job on so many levels. And I've listened very profoundly to your clarity of thought. I realize that there's a need sometimes to present a compromise when someone requests a variance. I think that's what you try to do, and I think you do a good job of that. Let me tell you a little bit about my neighborhood. I have a petition signed by all 12 of my neighbors, which is not many, but there's about 12 or 14 schools right around, 12 or 14 homes right around the sign that is supposed to be elevated to a height of 7 feet with an electronic message signal. I talked to my neighbors, door to door, petition by petition, listen to their thoughts. They're very articulate. They know what they like and they know what they don't like. And what they don't like, and they're not, to be very, very candid, as far as like notice and opportunity to be heard, I got a letter in the mail a week and a half ago and gathered as many signatures as I could and talked to them and listened to their concerns. I think the issues that my neighbors have, and I want to tell you about my neighbors, they have issues with the height. It's 7 feet tall. That's a large sign in a very sleepy little, quiet little dead-end neighborhood. In terms of the context of the neighborhood, I've heard Mr. Jackson speak to the context of the neighborhood and the signage or the homes that are there. We're not on Ridgeway Avenue. We're not on Quince. We're a dead-end avenue on Linfield and Grosvenor. It's a 7-foot sign. It's also electronic in nature, which is one of the reasons that they're asking for a variance. I don't want to live outside of Vegas. You know, my neighbors, it's not a question of 10 o'clock at night. Let me tell you a little bit about the school and a little bit about me. I've lived in this neighborhood since March of 2000, over 22 years. I've seen my neighbors come and go. The one thing that my neighbors have constant is it's a sense of community, and we can tell you about what happens at the school in terms of when people come and they go. They show up at 6 in the morning, they leave at 6 at night. Why do we need an electronic sign past 6 o'clock at night? I drove down Ridgeway Avenue the other day, and they have a 6-lane highway. Ours is a 2-lane road in front of a little bitty school in front of a neighborhood that you've probably never been to. You have to ask yourself, and I think to me the issue of the committee is you have to ask yourself, in a quiet little sleepy neighborhood, would you want a 7-foot electronic sign that's visible 24/7 outside of your house when you can hit it with a baseball from your front driveway? I think the answer is no, at least it is to me. You may have a different idea or a different opinion, and I respect that. But there are so many different, we talk about compromise. There are things that they could do. They don't need a variance for the sign. I think Mr. Williams, respectfully, I think he's selling signs. If you go to another case on the docket number 9, there's another case. I think someone said, you know what we can do is we can sell signs to all the city schools. It's for the kids, it's for the community, and we can get a variance on that, and we can put it out there, and it'll be great for the school. I talked to my neighbors. They said the school needs to be pressure washed. We need to tear down the basketball arena that they took the baskets off to put up a playground. We need to extend the playground. We need to put in nicer landscaping. We need to mow the grass more often. We need to, so many different things. We could use the money for it. I know you, Mr. Claybrook, you talked about, we're not supposed to talk about numbers, but I do want to talk about numbers just a little bit because I'm a CPA, I'm a numbers guy. And we could use the money for teacher salaries. We could use it for education. We could use it for after-school care. We could use it for laptops for the kids. We can do so many different things. All we ask of their sign is to keep it within the code that the city founders, both the city and the county, drafted so long ago. So we're not asking for much. We just want to leave our quiet, little, sleepy little community the way it is. And I have a petition here signed by all 12 of my neighbors, and I'd like to enter it. And to the record, if I could, again, the only notice that I got was a letter in the email and signed by my neighbors who I love and respect. And I hope that you can listen to us and make your decision accordingly. That's all I ask, and I appreciate your time.
Is there any questions of Mr. Kelly?
Yeah, Mr. Kelly, so I agree 7 foot is a little aggressive. Would you in the neighborhood be amenable if it was smaller?
If it was smaller in nature, the sign that's there is 4 or 5 feet. I mean, it could be a little larger than it is. And again, it's dated. I don't disagree with that. I grew up in that neighborhood. I've been there over 50 years. It's a dated sign, but there's so many different things that they could do with that sign to make it a little bit better. I don't want a 6-foot neon sign or a 5-foot neon sign any more than you would in front of your house, you know? So
I understand completely.
My neighbors are good people, you know, and I respect what they're trying to do to upgrade it, but I just think that there's a better way, and so do my neighbors.
Okay. Thank you.
Yes, sir. Thank you for your time.
Mr. Chairman.
Yes, ma'am. Ms.
When can I ask the staff a question?
Let's just real quick, just make sure there's
Okay.
no other questions for Mr. Kelly, and then we will relieve him of his duty, and then you can ask the staff a question now.
Okay, Mr. Penzies, my question is, with no variance, how much sign could they have out there?
If you were to remove the digital aspect of this sign, they would not need a variance. It's really the digital aspect that they're here for.
Okay. Thank you.
All right, Ms. Savage Towns.
Mr. Penzies, what is the height of the current sign that we have on page 9?
I'm not aware of the current height. I'm not sure. Oh. The applicant indicates they're not aware either. This is what it looks like.
Yeah, I wanted to know the height because I wanted to see if we could maybe get.
Don't have the exact dimension.
I bet that's a foot of just the base. You know, by the time you add up those bricks, they're probably 3 inches each. Angled too, but you know, to make it look taller.
Thinking we can stick with that.
5 and 6.
The neighbors indicated it's maybe 5 feet.
Angles make a big difference to do that. Okay.
Thank
you. Yes, ma'am.
I wanted to go just a little bit further. It just occurred to me, I'm sorry. But that street there, Grosvenor, how do you pronounce that, Grosvenor? Is that it? Is that a collector street or a minor street? What is that?
Grosvenor is, I live on Lovett. Lovett's a dead-end street.
We've already.
I'm asking the staff.
She was asking the staff.
Yeah,
Okay.
and it's, I'm asking the technical.
I believe the MPO classifies it as a local street.
Okay, and so they can have a 35 square foot sign on a local street there? Is it zoned
If
residential?
It's not digital. I believe that's the maximum size allowed.
Just because it's a school, but not on a single family home residence?
Because it's a permitted civic use within a residential district.
And that allows 35 square feet on a minor street, okay?
Any other questions of staff? You know, school's got to have some signs. We all know that, right? I mean, there's, you know, one of the letters of opposition that we got talked about all the things that the signs would say that really don't amount to a hill of beans, you know, I thought it was funny, you know, you can get your time and temperature off your phone, which is true. I think y'all read that email probably. Yep. But there are times they need to say something. And the little movable copy signs, while they're not bright, they look pretty gross a lot of times, you know, when they're not new. I think we're not even there yet. We still have opposition, or the applicant to come back. What I did like about what the neighbor said is, especially on this street, where if you're passing by this because you're picking up your kid from school. I mean, it's basically in the end of a cove, the way this street is designed. That why don't we limit it to, you know, 6 a.m. to 6 p.m. unless there's a school function, and not even work. And so now we're almost getting to where, except for in the dead of winter, I imagine they have after-school care. Most of those go till 6. Yeah. But other than that, you know, there's no reason to have to be blasting anybody with anything. But during the day, it wouldn't be as offensive it's just showing stuff. I don't really like that sign, but I'm sure that I imagine blue is also the school color, and you get what you get with some of the, the school colors and stuff like that. But I would like to amend when we get there to be that. And I didn't know if you have thoughts before we ask the applicant, who I'm sure is okay with whatever we say.
Can we say at least 7 to give the parents that are, we do have latecomer parents.
Not till 7 though. They start fining you.
I'd say 6:30.
Yeah, I mean, you get fined, I think, at those schools, like,
But I mean, you do have.
$5 a minute a lot of, at least where I worked at aftercare one time, it was $5 a minute
Yeah.
for every minute those were after 6.
I paid enough.
You did, really? I wouldn't have thought so.
Chairman Randy, do we want to restrict the size to no larger than the existing sign?
That's what I'm thinking, the size of it, the height of it, let us say, I'll say the height of it.
Yeah, I could do whatever on
Or
that.
something.
It has such
I don't
it has
know.
such a
Saying
big
it's already
base on it.
there.
It makes it bigger. Let me see if I can actually read
Yeah, but
this.
that's what 8 feet, if we can go back to the original.
Well, it's 7 feet tall, and it's 8 feet wide,
Oh, yes, yes.
with it being it looks like the top part's 2, the video's 2, the bottom part's 3, and then the width is, so you have a top part of 16 square feet that's just the Balmoral, and then you have another 16 feet that's the video or whatever. And is it a video sign, or is it just like, is it LED? Okay. That's just a static sign. So does that have the technology that I could like watch TV looking on, or is it just more like I could maybe show some cruddy fireworks? Does that make sense? How good is the video capability on it? Does that give anybody else heartburn? I don't know. I don't know if it does or not. I
I do have a question for the applicant. If we
Yeah,
do
you
reduce,
bring back, I was trying to get some of the stuff, but yeah, go ahead. Why don't you come back up here?
Because I think I'm in agreement with reducing or limiting the square footage of the signage if you're open to that. And so the question would be, are you open to reducing the square footage of the sign to?
Has this sign already been built?
It is not. No.
And not bought or anything?
No.
Okay. Do they have video boards that are 2 feet by, 6 feet?
I'm sorry.
Do they have like as far, I'm just like, if we narrowed the sign, it's right now it's 8 feet wide, is getting one that's 2 foot by 6 foot, is that even a possibility? I don't want to come up with something that doesn't make sense.
It's normally 3 by 6.
3 by 6, okay. But this was a special to get the 2 by 8. Somewhat.
Well, you can get them in,
You put it there.
there's several sizes.
Yeah, okay.
Yes.
All right, sorry. Mr. Jackson, okay. Mr. Malazar, you still have any questions?
No, my concern is what you were just talking about. We don't want to put a condition that makes it impossible for you or where we have to custom build a sign.
Okay.
Any other thoughts?
Mr. Chairman, I only had one other slight
Yeah,
correction.
go for it, Mr.
When
Mendez.
Mary and I were discussing before, we both said 35 square feet. It was actually 32 square feet, which is the maximum, and that is what they proposed.
Okay, thank you. Other thoughts before we discuss? All right, thank you, Mr. Williams. I guess you'll need to hang around a minute. Can we get a motion to approve this agenda item 2022-28 as conditioned by staff, and right now with the amendment, or not the condition that the hours be from 6 a.m. to 6:30 p.m. only?
So moved.
Second.
All right, is there any discussion on that or size or anything else?
Size, are we?
I got a question.
Yeah.
There There was a sign for a church that we had also conditioned about no flashing, the flasher signs or, the stuff that's really distracting for driving. I'm trying
There
to
used to
think of where
be
the
some
church-
sort of, with some signs, it could only change so many seconds, I believe, but 8 to 10. But
Okay.
how does that work if it actually can do a video?
Yeah,
Then it's constantly changing.
yeah.
Well, if it doesn't meet the requirements in the UC, they can be cited and, hopefully stop doing that.
Yeah, like I guess what I would say, my question to make sure, like, he's got an eagle on there. Let's say the video was a 10-second video of an eagle in flight, but it's moving, but it's the same video. Is that a violation of the 8 to 10-second rule as opposed to a static picture?
We're changing words,
Or do we just say static pictures only? And then we don't have to worry about it.
We're being the new age. We're trying to move digital.
No, I mean, that's what discussion's for.
Yeah, no, because we're trying to draw attention, or make it palatable, but we're talking about youth, and they're digital. They're digital children. So we want them to pay attention that you have a test on Wednesday, and that may be a video versus a flashing, you have a test on Wednesday.
Okay.
So.
I mean, if you drive past these, it's all up to whoever's programming it.
Yeah.
And generally, they 9 times out of 10 aren't that great at programming it. So it says the weather and the temperature, and you see them on shopping centers that show the logo of a business, and it scrolls to the next logo, and then
I'll take that answer.
Yes, their budget is very light. So
So we'll hold on that one. Is there anybody that wants to change the size of this sign?
Mr. Chairman, before we go past the hours of operation, there was a discussion about it being able to operate when there is an event up to 30 minutes after the event.
We would like that to be in our condition.
Okay. So when we
yes.
make the motion, that will be part of that motion.
Yes.
Okay.
Yes. Thank you for bringing that up. 7 by 8 feet sounds big until you're 30 feet from it. That's not very big at all. From a car, that's where it's off the street a little bit. Let's see this sign's sitting.
I have another question too.
Yeah, I mean it's less than 3 to 4 feet probably from that sidewalk. So it's right there.
that's close.
Chairman, I got another question as well.
Yeah.
For the applicant, is the Balmoral, is that backlit? The top part? So do we want to do anything with that or is that?
Well, we need to, are we okay hearing from the applicant?
Yes.
Sorry, I didn't.
Okay.
Yeah.
Question for you on that. With it being backlit, is the whole thing backlit or is it really just the white letters that will stand out? So is the blue translucent?
Yes.
It is, okay.
That makes it hard.
The whole board's like,
They wanted a shot.
everything. I think because we're cutting
Everything
down
cutting off does make it easier, right?
It does.
The other thing, another option with that would be to make the blue and the red opaque. So then you'd still better see those letters, but they wouldn't kill you going by if it stayed on. So could we maybe do a condition where the whole sign, if it's translucent, goes off at night? If only the white letters are translucent, then it would be allowed to stay. It's up to them, or is that giving too many options? Too many options. Okay.
Shut it down.
Sign shuts off at the 6:30.
Simple.
Okay. Any other questions?
Can I speak?
Yeah, go ahead.
So the EMC or the digital board in the software, it can automatically shut off at whatever time you tell it to shut off. As far as the sign,
I'm not sure what their capability is. If they have a time, what's called a time clock, which can do the same thing, but that's on the electrical end in the school. So if you wanted the sign to also shut off the top part of the sign, they may have to get electrical to add a time clock.
Yeah, go ahead.
Is there no way to fix it where all the electricity coming to the sign just cuts off at 6:30, period?
It'll be, well, the time clock could do that, but I'm not sure if they have a time clock already in place. And then there would be two circuits, one that runs to the sign or the top sign and one that runs to the EMC. So that's why you could run the software on the digital board and it would automatically cut that off because that would be a separate circuit.
There's no way to make the internal LED lights in Balmore Ridgeway cut off when the sign cuts off through the software?
Not through the software, not the top part. Just strictly controls the digital part.
Quick question, on the base where the address is that digital too, or is that just painted, or?
That'll be vinyl, just like door vinyl.
Yeah, just like the reflective vinyl. Would y'all, if I could see it getting complicated, turning that top part off. I also don't know what it would do, whether it'd be good or not for the software just to have the power to the whole sign repeatedly cut as opposed to it do that. Would y'all be interested in going back to the opaqueness I spoke of? So you just have a letter showing through, kind of like we talked about at our Northern Tool last week,
I think that's a good idea.
Okay. So yeah, we would want the top of the sign. So the top of the sign, Mr. Ragsdale, only the white portion, as shown in the site plan, would be translucent, with the rest of the colors being opaque. Any other discussion? Mr. Jackson?
And I just think from the ground to the top of the sign should be no more than 6 feet.
Okay. Any discussion on that height? So 6 feet? Okay.
The monument sign.
Let me ask you this: Are y'all are you getting rid of the brick that's currently there? It'll just be.
We're gonna fit that inside the brick.
Okay, so it'll be inside the brick. And you think that brick's probably about a foot, 15 inches at the most?
Mm-hmm. I counted the brick.
Yeah.
It's 1 foot 4 inches.
So 16 inches. So here's my thought on that. Not that I'm trying to make a big sign. It'd be nice if it was landscape still, but is that leaving us enough room, that at least 2 feet, I guess, right, above the brick that we could landscape if we have, because we're taking a 3-foot base and moving it to a 2-foot base, basically.
I think when they take the existing sign out, all that plant material is gone.
Sure.
So if they come back, they just need to come back with a lower evergreen.
And that low evergreen's fine.
Yeah.
Okay, good. Okay, that works. Any other comments? I assume you're all ready to vote. So we have reduced height to 6 feet. We have the only translucent lettering in white at the top. We have the sign shuts off. Hours are 6 to 6:30. It's set for during school events, and they can go 30 minutes past a real school event, and that's it. Correct? Okay. If you give us a roll call, please, sir.
We actually need to get a motion in a second on those.
Oh, yeah, can we get
Second.
All right. Thank you, Mr. Parliamentarian.
Unless I missed it, which I
No, you're good. You're good. No, that's what you're here for.
Ms. Baker?
Yes.
Mr. Claybrook?
Yes.
Mr. Malazar?
Yes.
Mr. Jackson?
Yes.
Ms. Scurlock?
Yes.
Vice Chair Savage-Jones?
Yes, I find that the standards of 9.22.6 of the UUC are being met and will not be unduly detrimental to the properties in the vicinity.
And Chair Rainey?
Yes.
Motion carries.
That case has been approved. Now we're moving on to, we'll call our next agenda item, please, sir.
Item number 9, BOA 22-032, 4851 Elvis Presley Boulevard.
And so we have another school sign. Mr. Jackson, did you have any particular thoughts on this one?
Yes, sir, I did.
Yeah.
First of all, I think that since they're changing, to the digital format, I think the height of this sign being, for lack of better words, on a pedestal is too high. I'm quite familiar with the area there on Elvis Presley Boulevard 51. It is just south of Shelby Drive. And after you pass that Exxon station that's on the southeast corner, there's a couple of the commercial shops, and it goes pretty much to residential and church all the way down to Holmes Road. That sign that's there now is already elevated. If you look at it, if you all have it on page 9, it's already elevated 1, 2, 3, 4, 5, 6, 7, about 3.5 feet above the street level.
Okay.
And now they want to take and put back a pedestal sign. I think they should go back with a sign very similar to what's at Balmore. Just it may be a larger sign area-wise, but it doesn't need to be a pedestal sign that's up in the air. Because there are no pedestal signs that I remember along that stretch of Elvis Presley. And the sign would be visible from the street because it's already elevated, plus it'll be elevated there. There's nothing to block the view of it. No vegetation there to speak of. Those are trees, so I think that lowering the height of it, not being a pedestal sign, would be what we need to do there as well.
How high do you think that is above street grade? Just estimate.
Well, you look at the number of steps you got. Yeah. 1, 2, 3, 4, 5, 6, 7 risers. 7 risers would be 3.5 feet.
And the curve.
And the curve. So that's 4 foot. So it's 4 foot above street level already. I would think an additional 7 foot height on that sign would be more than adequate.
Is that 4-lane or 6-lane at that part?
That
of Elvis
is
Presley?
a 5-lane cross section.
Okay.
Yeah.
And go back, and I know you said this.
Yes, sir.
What is your maximum height you're talking about on that?
Off the existing grade, I would think the maximum height of that sign should be 7 foot.
We're the same sign, just a 7 foot.
And hey, Mr. Penzis, could you go to page 12 of the staff report? Can you tell, it's, the width of the sign is right on that yellow. So I'm having trouble seeing, is it 7 feet wide?
8.
It is 8. Okay, so basically the same, well, different top, because the other one was 2 and 2. That's 2 and 3. So then you'd have a 2 foot base added to that to look similar to the other sign.
Mm-hmm.
Okay. Any other comments before, and then I'm going to, all right, if the applicant would come up on this and give us your thoughts on that as a sign person, is that tall enough? Are you worried about traffic or anything like that?
I believe y'all are correct. I think it's already sitting up tall enough.
Yeah. Okay.
They just wanted to use their existing poles and stuff like that is the only reason they wanted to keep that format.
Okay.
Save a little money.
Yeah. But 2 feet of base isn't like absorbently costly either. So, okay.
Not at all.
Yeah. Okay. I don't see any opposition on this case. Any other discussion on And here, are we wanting to limit out? I mean, this is on Elvis Presley. I know there's residential there, but to me, this is a different location than our last one that was.
I agree.
Dead end in a neighborhood that's
I don't think we should limit the time on
normal,
it.
whatever the sign ordinance says for brightness. Yes. That kind of stuff. Okay, that's what I thought.
Yeah, and two, it's a high school.
What'd you say?
I said two, it's a high school versus elementary. The number
true.
of activities,
Yep.
right, lots more things.
Yep. Many more events. All right, any other discussion? Well, hold on. Do you have anything else you need to add? Okay. Can we get a motion to approve BOA 2022-32 as conditioned by staff and with the condition that the height be no higher than 7 feet from the grade at the base of the sign?
So moved.
Second.
All right, any discussion? All right, I assume you're ready to vote. Mr. Ragsdale, you give us a roll call, please.
Yes, sir. Ms. Gerlach?
Yes.
Mr. Malazari?
Yes.
Mr. Jackson?
Yes.
Ms. Doss?
Yes.
Mr. Claybrook?
Yes.
Ms. Baker?
Yes.
Vice Chair Savage Towns?
Yes, I find that the standards of the UDC of 9.22.6 are being met and will not be unduly detrimental to the properties in the vicinity.
Chair Raymond?
Yes.
Motion carries.
All right, you've been approved. Thank you, Mr. Williams. Appreciate your time. Mr. Ragsdale, will you call our last case, please?
Actually, I believe we have two more.
Oh, do we? Okay, I'm sorry. Oh, I missed.
Yes, we had to pull one from feedback. So, the next one is item number 11, BOA 22-034, 4578 Sequoia Avenue.
Okay, I see the applicants here. Is there any opposition to this case on Sequoia?
There is not, and I have a letter or a card for support. I'm not sure if it's the applicant or
Okay, all right. All right, Ms. Payne, if you'll give us a brief staff report, please. Thank you, that's that. Yeah.
Good afternoon. I'm Margot Payne, Division Planning of Development. The applicant in this case is seeking a variance to allow a parking pad in the front yard of a single-family home less than 50 feet from the public right-of-way. The subject property is located at 4578 Sequoia Avenue in East Memphis. The property is zoned residential single-family 10. The surrounding land uses are entirely single-family. Here are site photos taken from Google Street View in 2019 showing the driveway at the eastern property line. Here are more current photos that were taken this month. The applicant is proposing to construct a 24 by 20 foot parking pad with landscaping in front of the home. The proposed parking pad would connect to the existing roughly 10-foot wide driveway that currently leads to a roughly 17.5 by 14-foot parking pad at the east side of the home. Staff finds that the property is not unusual from its neighbors in topography, size, or shape, but where surrounding properties have similar driveways leading to garages or carports, this property previously converted the garage to add additional living space. And the driveway now widens into a parking pad that is large enough to park 2 cars side by side. Space and access to this already existing parking pad could be increased by simply widening the driveway up to 16 feet as allowed by the UDC. Additionally, while the proposed landscaping surrounding the parking pad is adequate, staff finds the dimensions of the proposed parking pad itself to be larger than necessary. The minimum parking dimensions outlined by the UDC require 90-degree angled parking spaces to be minimum 9 feet wide by 18 feet deep, which would be 18 by 18 for 2 stalls. And the proposed parking pad dimensions of 20 feet by 24 feet could be reduced to be less intrusive into the established front yard setbacks. Staff finds that while the granting of this variance will not cause substantial detriment to the public good, it will substantially impair the intent and purpose of the adopted plan or the code and not be in harmony with the purpose and intent of the development code. Staff recommends rejection. However, if approved, staff recommends the following conditions. 1, the dimensions of the parking pad shall be reduced to meet the minimum parking dimensions per subsection 455A. And 2, any change or deviation from the site plan upon the determination of the zoning administrator shall be submitted to the Board of Adjustment for review and approval or administrative review and approval by the Division of Planning and Development. Thank you.
Thank you, Ms. Payne. Are there any questions for Ms. Payne? None right now. All right. The applicant is present. If you'll give your, are y'all both going to speak maybe?
Yes.
Then go ahead and give your names and addresses for the record.
Yes. Shauna Walker, I'm the owner of 4578 Sequoia, Memphis, Tennessee, 38117.
Johnny Walker, 4578 Sequoia, 38117.
Okay. Y'all swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Oh, choked up there. Sorry. Go ahead, Ms. Walker.
I have some additional
Sure.
handouts.
Excuse me. Thank you. Okay, go ahead.
Okay, thank you. So I also read in the staff report that 2 cars could be parked side by side on our driveway. The Google Maps shows the photo. That was a previous owner who parked side by side, and this was likely before the AC unit was installed there. That does cut into that space that you can see from the photo that I handed out there. There's a larger photo on the second page, if that helps as well. The driveway at the top where you can see it's larger, it actually pinches back together into a single lane where the front landscaping begins. So we took an example picture of a Honda Civic here, which is a smaller car. You can see on that side of the driveway, it's about 4 feet, 10 inches, and the size of this fairly small car is 5 feet, 9 inches. So it's very difficult, even if you have a car up there, to be able to back up without running into driving over the landscaping. The same thing is the case on the other side. There's actually yard there that you would have to drive over to actually get out of those spaces with 2 cars parked there. So that makes it very difficult. It also in your packet, the second packet that was attached there, there's more than 11 homes of examples of parking pads that we collected within our area that we were made to give here. And
Just add on that. So that is Berkeley to the west, Charleswood to the north, Perkins to the east, and Sequoia. And ballpark, that's about 25% of the houses in that neighborhood have pads of some sort. Pictures. If they're not good, it's me. I'm not very good.
So the addresses and the pictures are there for you.
Sure.
That does not count circular drives that are also in the area. So the other thing to note is in those example homes, many of them don't have landscaping, and I know if you require approval now, you do want some landscaping that does hide a parking pad. 2 houses down from us has a fairly large parking pad. There's 0 landscaping around it. There is a house right across the street and down one house that has a parking pad. They have a 3-car garage and a huge parking area and a parking pad, but it does have landscaping around it. It looks very nice, and that is what we were going for, a very nice looking installation with landscaping that we included on our plan there. So I also included some information on parking on the street and the issues that it causes. That's one of our biggest concerns there because, cars parked on the street can complicate trash pickup, making it difficult for the sanitation workers. We've already seen that a couple times with trash cans and them having to go around cars. It's very difficult. Cars on the street can be more easily damaged. They just crowd the streets. They're unsightly. More importantly, in one of the letters that you received from one of our neighbors, actually from Susie Kirkland, she's a Memphis police officer. She's one of the first people I met when we purchased the home in December. And the first thing she said was, don't park on the street because your car will get broken into. And she says in her letter, her husband's car was even stolen when it was parked on the street there. So just the theft and damage that can be caused is a big concern. So we had originally asked to install a circular drive. not formally, I had just emailed to see what the process would be, and we are encouraged to do a parking pad instead. And this is by an email exchange with Mr. Chip Saliba. So, yeah, I wanted to share this information with you and request, so what, I realized the rejection was based on the size of the pad. We did come with another proposal. It's in your packet, a smaller one, if that would be considered instead. So it's an 18 by 18. You'll see there is a sliver of a 6 foot on the side of the driveway, which would be considered. The 6 foot makes the driveway a full standard driveway space, and then the additional 18 feet. There should be an additional site plan in the packet. Yes.
Perfect.
Sir.
I think it's
Thank
page
you.
3 of what you gave
So
us.
we're proposing if that would be considered instead as a compromise.
Do you know from this, between these two site plans, how much closer or how much further away does that put the drive, like the part of the driveway that's perpendicular to Sequoia? How much further away is it set back now? I don't see that on here. I mean, I'm sure it's something.
The setback.
Probably 2 feet. It probably took the same thing and just shrunk it 2 feet to make the 20 to 18.
Yes.
So
The full setback is 50 from the house to the curb. So the low 20s, I would say. It's hard to tell from that. I did not.
yeah, it
measure
is.
that. I'm
Yeah.
sorry.
Okay.
It's my fault. I did all the measuring.
Stop, Pete.
You didn't move the pad any further from the house. You just shrunk it from, this,
From
the
the
width.
street.
Yeah, okay.
Shrunk
So
it
it
up.
added 2 feet of
To the yard.
of grass
from
or
the
whatever
street,
by the
yes.
time you put everything in.
Yes, sir.
Okay. Are there any questions for the applicant? Ms. Baker? Yes.
I have a question. It was mentioned by the staff, and I see it here on this photo, that you have a building there that was a garage that is now living space. Did you make that conversion, or was that already like that when you?
That was like that
Okay.
when we purchased it.
All right.
We have not made any exterior changes.
Okay, thank you.
Other than the pine trees you saw in the first photo from Google Maps, we got rid of all those. So
Yeah.
it looks a lot, it's aesthetics, the house, it's beautiful.
cleaner.
The street, it's nicer. What we're proposing, this is not a nasty pad that's just gonna sit there. Aesthetics are paramount for us. The neighborhood, I know there was a letter of opposition, which if you read what was in there, talked about there are no pads, or that's absolutely false. You've seen the pictures. For the neighborhood, for the area, with your approval, whatever we are able to put in there, the place is gonna look nice.
And the pine trees, actually, when we first moved in, we talked to both of our neighbors on the sides of us, and that was one of the things, like, these pine trees are awful, because they would drop, even on the street, they would drop pine needles everywhere. And so we took them down to help us and our neighbors. So our goal there is just to improve the house, the look of it, our neighbors. It's something that, is top of mind for us, for sure.
Any other questions of the applicant? Okay, thank you very much.
Thank you.
Is there any opposition to this case? Ask one more time. Okay, seeing none. Could we get a motion to approve BOA 20-22-34 as conditioned by staff? So moved.
Second.
Question.
Yes,
Are we approving the new?
we're going to talk about it. Which one would you like to approve, Ms. Savage Towns? Or which one would you want to?
I think they did a good job on the revised one and
Yeah.
pushing everything back and kind of shortening the pad itself, the width of the pad.
Chairman, what is allowed, or Ms. Payne, what is allowed per the UDC for width?
For a front parking pad, well,
She said 16. Okay.
it's not allowed. A front parking pad is not allowed if it's less than 50 feet from the
Gotcha.
right of way.
Okay. Right.
Mm-hmm.
The driveway is allowed to be 16 feet in width.
Say that rule again real quick. The parking pad's not allowed unless it's 50 feet from the driveway? Is that what you said?
Yes, with adequate landscaping as well.
Okay, so it needs to be a pad further away from where the drive actually is what the code looks at. Is that right?
From the right of way.
Right of way. Okay, I can't hear out of one ear today. So,
How far is it?
I don't have the revised plans in front of me, and it's not mentioned here. The house is at this 50-foot setback line, the front of the house. Thank you.
if I had to guess, it's 20 feet from the street. I mean, like it's barely over the width of the parking pad to get to the front setback line, and that front setback line is the sidewalk. So you also have sidewalk and tree yard. So it's probably close to, I'd say it's 28 feet from the street.
Not quite 30.
You know, because again, because the right of way is from the edge of is not from the edge of curb like we always think of the right of way being. It's usually the back of the sidewalk. So just for context.
Wide is the parking?
How wide is a parking pad allowed to be again?
The minimum standard just for the UDC is, let's see, for each stall, 9 feet wide by 18 feet deep. That's for a 90-degree angle.
Right, okay.
So what they did is they reduced it to the minimum requirement.
Right.
Yes.
Because it's too close to the street, we'll just do the minimum. Had it been further, they could have been a little bigger and stuff like that.
Right.
Okay. Any other questions or thoughts? Could we all agree that we are voting on the revised plan as our site plan?
Agreed.
That's in agreement. So that's the revised plan provided by the Walkers. All right, any other discussion? All right, I assume you're ready to vote. So, Mr. Ragsdale, if you give us a roll call, please.
Ms. Baker?
Yes.
Mr. Claybrook?
Yes.
Ms. Doss?
Yes.
Mr. Jackson?
Yes.
Mr. Melazar?
Yes.
Ms. Skurlock?
Yes.
Vice Chair Savage Towns?
Yes, I find that the standards of 9.22.6 of the UDC are being met and will not be unduly detrimental to the properties in the vicinity.
And Chair Raymond?
Yes.
Motion carries.
All right, thank you all much for coming down. Enjoy your parking pad. Mr. Ragsdale, will you call our last case for us?
Yes, sir. It's item number 14, and that is BOA 22-038, 2396 Poplar Avenue.
Okay, is the applicant present? And is there opposition on this case? Or
There is not. The applicant, I think, will discuss a couple of conditions.
Okay. All right, if the applicant will come forward, we can start with your discussion to the conditions and go from there if we want to do that. And if you'll give your name and address for the record.
I'm Jim Shumpert with the Reeves Firm, 6800 Poplar Avenue in Memphis, 38138. I'm not the applicant, but I am the representative.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead, sir. Anytime you're ready, yeah.
All right. Midtown Nursery is occupying a parking lot on Crestmere at the corner of Poplar and Crestmere, owned by First Baptist Church, which has been unused before now. And it's leased to Midtown Nursery and provides revenue for the church and a space for the nursery, which is a thriving business for about the past 15 years, and it's been operating at this location for the past 5 years under special use permits. And we're now seeking a more permanent solution for permitting the operation.
Are there any, I lost something there. Were you here to talk about conditions and I just missed what you wanted changed? Because I'm sorry about that.
There are 3 conditions that, that we'd like to discuss. One would be the buffer between the homeowner adjacent to the property to the north, the streetscape, the chain link fence, and I think that's about it. There is one more condition that repairs to the sidewalk, which we don't have a problem with.
Okay, Mr. Skinner, could you give us an overhead picture of the site?
Absolutely. So,
I don't have
this is their site plan. It just gives somewhat of an adequate picture.
Yeah, and this is basically, as I said, it's more or less just a parking lot, but it does have chain link fencing around it, a portable building, and shade cloth over a portion of it to protect the plants. There's nothing permanent built on this site.
Okay, and so they've asked that you do landscape screening and everything in 4.6, and you're not wanting to do that?
Oh, I wouldn't say we're not willing to. We'd like to discuss maybe some options if
Okay,
we could.
Okay, what are you thinking?
Well, Mr. Ernest is perfectly willing to change the fence out. For instance, it's chain link now, and he's willing to put up a vinyl coated chain link fence along the street frontages, and we'd like to discuss maybe if that would suffice for the streetscaping. I realize this is a lot to ask, but we are asking it.
What kind of lease does he have? How long's his lease on that site? Do you know?
That I can't answer. How long is your lease? Know how long it'll be? 5 years.
And the fence required, Mr. Skinner, would be like a wrought iron fence? Like it'd be a...
So they have CMU1 zoning. They would be allowed to do like a PVC coated chain link, but as this current chain link fencing would not.
Okay, so PVC, like...
Sorry, yes, with landscaping added.
Okay.
Apologies.
And the hardship with putting in the streetscape along Poplar is that there is no planting area presently. It would require him moving his fence, which if he was going to put up a new one, would not be that big a deal, but we would have to remove the asphalt for the installation of the trees.
Yeah, I mean, I've never minded that site being there, but it's looked pretty crappy. I mean, that fence looks terrible, and I know you're going to replace it, but it seems like if you're going to go ahead and put in a real fence that's actually in the ground as opposed to, I mean, I may not be able to see the picture well, which is very likely. It looks like it's like a portable fence currently there now, where maybe they put the little sandbags around the bases so it doesn't fall over. And I think we just need, if we're going to use it as a site for 5 years, we just need something that looks a little more permanent. And that would include landscaping. That's my thoughts.
Mr. Chairman, along those lines, I wasn't going to pull this one off to discuss it, but when I go by there, and I think this would be considered a change in use since the other one was there temporarily, approved under a temporary permit. And doesn't that require new sidewalks? I mean, aren't they supposed to rebuild the sidewalks when they change the use of a property? Isn't that in that chart and general development standards chart in the UDC?
I mean, I do believe that would be correct. Granted, there is no new construction, but yes, it is a change in use, yes.
It requires sidewalks, doesn't it? Sidewalks and landscaping. That's what I'm asking. I think it does.
Sorry, well...
So that would just be another variance we're approving if we're saying they don't have to comply with that, I guess.
It's not a change in use category. We were going to look at that. So it's a change in use, but not a change in use category. It's commercial to commercial, I believe. So.
Oh, so you go by category.
Correct.
Okay.
So it may not trigger that. But of course, we can, you guys can discuss and condition however you would like.
If it's not required, I mean, it's a big expense, I don't know. But it looks terrible, and it's...
It looks a lot better when there's plants behind it, because it does draw your eye away from it.
No,
when you
I
see
don't
it
think
empty,
the
you're
site
like, oh,
looks
goodness.
bad, just the sidewalks are all in bad condition.
Well, right now, I just left there the other day. Right now, there's, the lot is full. It doesn't look like that. So the lot's full right now, and then it'll be like, I guess through the fall, right? There's stuff for fall on the lot. And then in the winter seasons, it's not I think it's empty in winter, right?
He sells Christmas trees until.
Oh, and then Christmas trees, and then it's empty for a couple of months. So right now, it doesn't look like that because it's full, it has plants.
You kind of see the plants aren't in front of the fence, but there's just
Yeah,
plants
but it's
all
just
behind
full.
the fence.
Yeah.
You see, yeah, that makes sense.
Yeah, and so my question would be, since this is a lease, I mean, having to drill the asphalt to create fertile ground, I mean, good dirt for planting, although they are a nursery, which, I mean, I guess, they know something. But would they be able to pot it, like have a row of like potted plants, or would that make a difference? Does that make sense?
We need a plant expert.
What about Mr. Jackson?
Mr. Jackson.
I was looking at you. So does that make sense? Does it make sense to do like maybe a row of potted plants to make it look better or different?
Mr. Dawes, I like your idea. First of all, Ms. Chumper, good to see you.
Good to
Seen
see
you a
you,
long
John.
time. Mississippi State grad. I would think, yes, that instead of, taking out the asphalt, just do some type of potted plant material, maybe trees in pots, that might advertise it as being a nursery, and if at the end of 5 years he was leaving, he could pick his pots and his trees up, take them with him, or he could sell them to somebody.
Yeah.
But I would think that the chain link fence with the potted plant material would work well.
Okay.
Mr. Chairman, Mr. Jackson, what if we required him to do a black coated chain link fence, with the,
Oh, definitely, I would say yes.
that would make it look a lot better. There's actually a corner near my house at Cooper and Central, and they've set up a taco stand there is what they've done, and they have a black coated chain link fence and these giant planters, and they have
It's the old location for
magnolias in them.
Midtown Nursery.
Right, it is.
Right?
Yes, it absolutely
Yeah.
is, yeah. So I just think a black coated chain link fence would look,
So I think their minimum on a fence is it has to be PVC coated, and we're just going to require that if they use a chain link fence, it would be black, correct? That's really what we're adding to that.
Yes.
Okay.
Now, would that be along all frontages or just the streetscape frontages, the vinyl coated fence?
It would be Poplar and the street to your
street.
west, Crestmere. Yeah, I would think that would be adequate.
The parking lot that's on the back, does that serve the building there, or does it serve the church, or both? Do you know, to the north?
Yeah, of course, it's owned by the church, but it does serve the nursery.
Okay.
That's a fence though. That's a fence on the back lot, right? Where the parking lot is? That's a fence already there.
Well, it stops on the site plan. You can see that little portable building.
Yeah.
That's where the fence runs across from east to west back there.
Okay. I think we're saying on the other side.
I think the whole fence, if it's chain link, it needs to be the PVC coated. I mean, I know it's just a parking lot for it, but it's just going to look better to have that.
So, Mr. Chairman, what
Yeah.
you're saying is along Poplar, Crestmere, and at the backside of the portable building, all that would be a
Correct.
vinyl coated black chain link fence.
And even and along even the east beside that building, but beside the large building, if there's a fence there,
Yeah, wherever there's fencing, then there would be.
if they're putting up
vinyl
chain
coated.
link fence, it needs to be vinyl coated.
But on the north side, there's already where we park, when you come into the lot and then you pull this way and park. Isn't there something here already by the parking spaces?
Between the house to the north.
There's already a something.
A portion of that does have an existing wood fence.
Yeah.
And I'd like to get to that in a minute.
Yeah, I'm not talking about that.
Okay.
Yeah.
Okay.
Where they have the chain
But if there is chain link on the site, it should be vinyl coated black.
Roger
Yeah,
that.
yeah,
Got
yeah.
it.
That's
And what we were also saying, correct me if I'm wrong, is trees and pots would be along Crestmere and Poplar Avenue.
correct. That's what I would think.
Yes.
Do you have any thoughts on that, or does that get you somewhere close to what we need to be?
Yeah, I think so. I think
Okay.
we're good with that.
Okay.
The next condition would be the buffer, and we certainly want to install the buffer, and we have a letter from the homeowner to the north. She wants her existing plant material to be the buffer on her property and put the, an extension of the wood fence westwardly to the property line to be on the common property line. So this would be a modified buffer in that instead of being on the nursery property, it will actually be on her property, but that's what she wants. We'd like to see if we can do that because we'd lose some substantial parking space for one if we didn't do that, and also we want to keep her happy.
Yeah, Mr. Jackson.
So, Mr. Chairman, let me make sure I understand what you're saying. Where the nose-in parking is at the north property line, you would need to extend the wooden fence where there is none.
That's right.
And take the planting that would normally be put on the south side of the fence. She would like it on the north side of the fence on her property.
That's right, and it already exists. She's got a double row of evergreen trees as if she was planting a buffer on her side.
Yeah.
You're all willing to do that? I don't think the board has a problem with that.
Yeah, I don't think so.
That's what the neighbor wants on there.
If I could just speak to that for a couple of seconds. Because of the change in the zoning districts, that's why the buffer is needed. Staff would be okay with having that buffer, a modified buffer like that. That's fine. They can keep the parking and the neighbor can keep their buffer. We are fine with that.
Perfect. All right, any other items?
I believe that's it.
Okay. All right, Mr.
Chairman,
Ragsdale.
I did want to, we haven't made a motion yet, but I think if you could go through, I think I've got most of the stuff you guys were talking about. I did want to ask, sometimes whenever you guys condition something with, like this chain link fence, you might condition it to have a sunset if you, like up to 5 years, and they could come back for correspondence if the lease goes longer, just something that you might want to consider. Usually you guys think about that when you're putting something like that. So.
Okay.
I have one more question.
Okay, go ahead.
Mr. Chairman, could you tell us what would be the spacing you would propose on the trees and pots on Crestmere and Poplar?
30 feet.
Okay. Staff? 30 foot? Would that work?
Yes.
If not, just say no.
Yes.
Staff's comfortable with that?
We're creating something. They're like, what? We're creating a look here.
And Mr. Chairman,
yes, please.
And I would like to add to that if Mr. Shumpert, your client could put that all on a site plan and provide that to staff for review.
Sure.
So we have a documented record of that.
Okay, we sure will. Thank you for asking that question. That was good.
Okay. So let's see if someone could give a motion to approve BOA 22-038 as conditioned by, let's make sure. With the following conditions. We'll keep number 1, we'll keep number 2, and then we'll have a condition that if any chain link is used on the site, it'll be black vinyl coated chain link for the fence, which the landscape screening shall be allowed to be potted trees on 30-foot centers, and the northern landscaping buffer shall be allowed to be on the neighbor to the north property as presently constructed.
Chairman, I'm sorry, but I do have one more question.
Yeah.
What is the height of the chain link fence that we're requesting along Crestmere and Poplar? Do you have
What's the current?
6 feet.
What's the current one?
6 feet.
I would do 6.
6 feet.
Think only 5? 5 feet.
We think it's 6 feet.
Can we do, is 5 acceptable?
No, it's 5.
5.
Yeah, I was thinking in my head. Well, okay, chain link, and then as far as the chain link, it can't be any higher than 6 feet.
Chairman, I've got a question too. On the chain link, should we add in there that it's to be permanently affixed and not the temporary that's?
If we need to do that, I thought like code would require
Oh, okay.
that.
Yeah,
But
just wanna make sure.
But that's a good, yeah, definitely we need to find that. Is that needed, Mr. Ragsdale? Okay, so okay, good, thank you.
No higher, are we putting a minimum on that, minimum?
No,
Or
it is
should
6, period.
Definitively 6 feet.
The fence, yeah. Okay, any other, do we have that motion?
So moved.
Second.
Is there any discussion? All right, hearing none, I assume you're ready to vote. Mr. Ragsdale, if you give us a roll call, please.
Yes, sir. Mr. Milagro?
Yes.
Mr. Jackson?
Yes.
Ms. Baker?
Yes.
Mr. Claybrook?
Yes.
Ms. Doss?
Yes.
Ms. Scurlock?
Yes.
Vice Chair Savage Childs?
Yes, I find that the standards of 9.22.6 of the UDC are being met and will not be unduly detrimental to the properties in the vicinity.
Chair Rainey?
Yes.
Motion carries.
All right, it's been approved as condition. Do we have any further announcements, Mr. Ragsdale? All right, with that, this meeting's adjourned.
Good to see you.